Any mention? Item number 1.
There are two status reports filed in the matter, my lord.
Two status report files.
One in respect of the MCPIL, my lord, because the MCPIL has been registered separately by your lordship. So first I will place, my lord,
first you will place
the status report in the main matter, my lord.
I'm in matter. SIT.
Your lordship would recall that there were a number of issues which have been flagged by your lordship in your lordship's order of 27th April, my lord.
1 second. Yes.
And your lordship we have tried to answer each of the issues point wise, my lord.
Okay. Then you take it forward. Yes.
First issue, if lordship will kindly see at page 1, my lord. With page 1, paragraph 3, my lord.
Yes.
Strict compliance, my lord.
1 second. It's too much cloudy.
Page 1, paragraph 3 of the report in the main PIL, my lord.
These are just proposals.
Yes. Yes.
Lordship will have the paragraph 3 at page 1 at the foot of the page, my lord.
Yes.
Strict compliance of standard operating procedure to 2024 for transportation of coal and issuance of so-called notice for violation of standard operating procedure. Now, you also would recall that there was a truck laden with the coal which was being transported by Star Cement from outside to its factory. So then the direction was issued to the department, my lord, to take action in the matter. Paragraph 3.1, my lord, I am placing that paragraph. Mining and Geology Department, Government of Meghalaya and the Directorate of Mineral Resources will strictly ensure all provisions of SOP and are fully complied with the applicants prior to granting approval for transportation of coal from the outside the state, my lord. The direction was.
So that is all. What happened, Uri?
And we have
detected last time was that this coal was moving without any documentation.
It was moving without following the process SOP, my lord. If your lordship will see the standard operating procedure, so then in that case, my lord, a lordship would recall that under rules have been framed under the Meghalaya mineral transportation rules, my lord. That notification was there, which is dated, my lord, 2020, my lord. It's called Meghalaya Mineral Prevention of Illegal Mining Transport Storage Rules, my lord. So in that rule, there is a provision of initiating action against the party, my lord. So in terms of that, if your lordship will have that page again, my lord, paragraph 3.1, we have issued so-called notice to the Star Cement as to why action be not initiated against them, not for not adhering to the report or the rules, because their case is, my lord, that they have applied before transportation of the coal, my lord. So this aspect is
what happened if they applied nothing happened after that, then how did it
yeah, and that matter was pending, and there were certain because requirements which were not fulfilled. That is why so cause, if your lordship will have so cause, we issued a so cause to them, my lord. I'll take your lordship to the show cause separately. First, your lordship will see the compliances, and then I'll take your lordship to the show cause we have issued. And once we receive the reply from them for compliance or non-compliance, my lord, we'll take action, my lord. Paragraph 3, my lord.
Yes.
So that report is there, my lord. Your lordship has the report.
Where's it? At page?
Page is page. Your lordship will page 2, my lord.
Page 2?
Page so called page 2 and paragraph 3.3.
No, you're not annexed.
And I have annexed the so called, my lord. If your lordship will have the so cause first, I'll page 19, my lord.
19.
Page 18. Sorry, page it goes to. It starts from page 15, my lord. Lordship, violation of standard operating procedure 2024 for transportation of coal from outside, and we have unauthorized and beyond the approved quantity coal, my lord. No approval clause of SOP 2024, my lord. Non-compliance of clause, prior notice and weekly returns. Non-production of mandatory document under 789, my lord. And so we have issued so cause notice to the company, and we have enclosed the storage rule of 2022, and that is 7th interim report, my lord. Once we receive the response, my lord, we'll pass appropriate
How many
order.
days have you given for them to respond?
We have given, my lord, if your lordship will see, 15 days, my lord, at page 18.
This was issued on 15th May.
May, yes,
have you
my lord.
received any response?
That instruction I have to
Okay,
take.
today, yesterday, 31st.
Yes.
Fine, so you'll be, yes.
That instruction I have to take.
Yes.
So this is the detail. Each and every aspect has been taken note of, my lord. Now kindly come back to the report again, my lord. Then the second issue, my lord, your lordship has then with regard to paragraph 4, my lord, investigation into violation, page 2, bottom, my lord, SOP in relation to transportation of coal from outside the state, including connection with Clarion PS case 106 or in the alleged.
You've said just now.
Yes, this is going on, my lord, and we have then, my lord, the next issue, your lordship will find at paragraph 6 at page 3, my lord.
Yes.
The payment of compensation.
No.
No, because what has happened, my lord, that we are asking for the, if your lordship will see, we are just asking somebody to come forward, and if your lordship will see paragraph 6.2, it is submitted that certain documents relating to proof of legal error and kin are awaited from claimant side, and immediately upon receipt of verification, same compensation shall be released, my lord. I have that process is on, and we will release it, my lord. Once
no more doubt about the.
No, because your lordships passed the order to give, so we have to give. There is no question of not paying to the. That order was clear in 27th April, my lord. So we are complying with this order, only procedural aspect. Now, my lord, accountability issue also, paragraph 7, if your lordship will have, fixation of responsibility and accountability upon officers for prevention and detection of illegal coal mining activities, my lord.
Yes.
It is in the compliance with the recommendation of committee and continuous communication of so and so mining and geology department. The accountability mechanism is proposed to be incorporated to prevent. This same is detailed herein.
Okay, yes, continue.
Yes, paragraph 7.2, my lord.
Yes.
This deputy, sir, at page 4, my lord.
Yes.
7.2. Deputy Commissioner East Jaintia Hill, District Superintendent of Police East Jaintia Hill, and Divisional Mining Officer Director shall be responsible and accountable in the event of occurrence or continuation of illegal coal mining within their respective jurisdiction. That responsibility relating to transportation and movement of illegal mined coal shall rest with the District Transport Officer East Jaintia Hill, being the designated authority responsible for regulation and monitoring of vehicular movement within the district. It is submitted since the scrutiny and verification of transport challan, transit permit, related transport document fall within the statutory mandate of Mining Geology Department. Accountability relating to transport, procurement and movement of coal destined for cement units shall also be fixed upon the concerned authority under the Mining and Geology Department. So we have made all these officers accountable, my lord. Now paragraph 8 is with regard to the Garuda, my lord. a transportation of illegally mined coal identified during aerial survey conducted by Garuda UAV Software Limited to designated depot, my lord. Out of, my lord, 1,43,939 metric ton of coal found during physical verification of coordinates identified by Garuda UAV Soft Solution. Approximately 1,24,431 metric ton of the coal has already been transported to designated depot. It is further submitted that 19,500 metric ton of coal stock whose coordinates coincide with the petitioner submitted by Sri Matthias Berloi on behalf of coal owners is under process. Transportation of seized coal is presently in progress, and until 27th April approximately 2,400 metric ton out of has been transported, my lord. It is submitted that certain practical difficulties are being faced in transportation in much scattered location of coal stock require prior accumulation before transportation, poor condition of Kacha road particularly during the rainy season, my lord. So only we are facing hurdle with respect to 24,000 we have transported, and we are facing hurdle 19,508, which we will do that also, my lord, out of which we have done. Now, my lord, this auction by reassessed, re-verified coal, my lord, this 3,72,908
progress here.
Yes, my lord, we have made huge progress in this, my lord. If you lordship will notice that 3,72,900 metric ton of re-inventoried coal was put for auction by MSTC on 28th April, out of which 3,45,051 metric ton were successfully auctioned, my lord. This time we have achieved that. Therefore, out of total 4,10,710 metric ton of re-inventoried coal and assessed through the aerial drone, only 27,857 metric now remains to be put auction, my lord. So we have achieved substantial progress with regard to auction, thanks to
that
MST.
means from April 28th, only within 1 month.
Because the auction process was, my lord, it is placed on, once we give the data to MSTC, MSTC will put it on the website. They give the time, and auction has taken place on 28th April, my lord. 28th April. Auction has taken place on 28th April by MSTC, my lord. Only 27,008 now remains to be auctioned. That
You mean to say after this amount is auctioned, there'll be no more?
No coal left of legacy coal. There will be no legacy.
Any depot.
Any depot. Depot will be there because my lordship has those designated depots are being utilized for transferring the illegal coal,
right.
But not for
what we are saying is that with regard to reassess.
Yes, my lord. This chapter will be closed, my lord. This chapter will be.
That is at least one positive.
At least there will be peace to that extent, my lord. That otherwise this was a lingering issue, which was. Now, my lord, recovery of unrealized demurrage charges, which was also a recommendation from the defaulting successful bidder. The total demurrage charges of 45,13,000, out of which 32,85,822 has already been recovered, my lord. And Baki Jai notice have been issued to, my lord. Baki Jai notice.
Yes,
my lord. Now, there was a recommendation by Justice Kataki with regard to some DMR check gates in vulnerable areas and other check gates, my lord. It is submitted that the regard of establishment of integrated DMR check gates at Nangal, Birbira and Medi Patthar railway station and Rongraj and Dana Dubi, two locations namely Nangapa and Rongbil, have been identified. That process relating to identification and acquisition of suitable establishment of said check gates is presently underway. With regard to proposed check gate between Nangali Bira and Gaswapara, an inspection was conducted in 24 office of South Guard along with officers of police station. During the inspection, a plot of land situated at Kasaipara between Bagmara and Gaswapara was found suitable for establishment of proposed DMR. The process of establishment of check gate at identified lies underway, my lord. It is submitted that Mineral Sources by 8th May has sought government approval for conversion of existing temporary DMR check gate in Medni Patthar area and not into a permanent smart check gate, my lord. That SDO Civil Mausirat has been directed to identify suitable land for establishment proposed smart check gate in Atiyabari area. It is submitted Mining and Geology Department is presently awaiting proposal to integration of check transport, my lord. We will take steps in that regard also. 12.8 Deputy Commissioner North Garu Hill also instructed District Transport Officer North Garu Hill to take necessary steps for shifting the integration of Transport Department check gate with DMR integrated smart check gate at Dana Dubi 12.9 with regard to establishment of smart check gate and at Nongali Bira and Medini Patthar railway station between Rongjeg and Dana Dubi, two locations namely Nappa and Rongmil have
Same
been
one
we have taken steps in that regard, my lord. So, my lord, then for other district, my lord, serial 14 paragraph 11. For prevention of in other districts also, we have prepared common action plan for.
1 second. Yes. What is this one, Mr. RP Channel? 13.1.
13.1, my lord, your lordship would recall.
Drawing alternative.
Yes, your lordship would recall that the one of the recommendation of Justice Kadaki is to find out the alternative means for those who have been affected by ban on mining, my lord. So
no, why is it come here?
This should have come in the because a common action plan.
About your integrated
and
check,
this is
correct?
Yes, this should not have been here, my lord. This should have come in the subsequent paragraph where this is by inadvertently it has been placed here, my lord.
Yes.
Now, my lord, preparation of common action plan, your lordship has seen, except for that part, my lord. Now, if your lordship will see that we have constituted paragraph 14.2 at page 11 foot.
Yes. Yes. Now you come to page 12. Now it is two additional deputy commissioner judicial. Who is he?
Now, my lord,
why judicial is given here?
Judicial should not have been there, my lord.
Why judicial?
Yes, my lord, your lordship is right. Let me place the annexure, my lord. Annexure 5. Annexure 5. Yes, my lord.
What page is it?
Yes, annexure 5, my lord. Page. It should not have been there, my lord. It missed my attention also, my lord. Yes, page 30, my lord.
Page 30?
Yes, my lord.
Who's the person name?
Secretary. He should not be. Because now separation has taken place.
Yes. And this is your
yeah, it's my job, my lord. We have to amend it. Because now the case management, if your lordship will see page 30, duties and function of case management, all cases, complaints received, notices filed to ensure they know something is missing, my lord. So he should be admin only, my lord, not judicial, my lord.
Case management proposes all cases, complaints received, notices and filed to ensure then order. Case disposal, conduct inquiry, illegal coal mining.
No, it's not. There is.
But this is not a judicial function.
This is not a judicial function.
The receipt of a complaint.
Yeah, error is on our part, my lord. We will correct it. This has. I never thought that they will incorporate.
No, additional deputy commissioner well and good, but I mean the duties are fine also. But the
yes,
only thing is that
other members are fine, my lord. So far,
not correct. Yes,
yes, my lord. This will amend the notification, my lord. Yes. This is because of error on their part, my lord. So these are the actions, my lord, which we have taken in respect of recommendations and order pursuant to this, my lord, in the main PIL. Now, my lord, in the MC PIL, my lord, if your lordship will have the MC PIL. Because all these cases, my lord, the issue which was there, if your lordship would recall, that what is the role of SIT in each of the case and whether you have been taking action against landowners, Sardar, etc. or not. We have made number of arrests of landowners, Sardar, etc. also of the affected areas, my lord. The other issue
been filed.
Charge sheet have been filed in number of cases. If your lord, those details are there. If I just show paragraph 3,
just skim through them, yes.
Yes, paragraph 3, my lord. So each case, my lord, SIT is taking systematic.
I hope you're not only apprehending or arresting the small fry.
No,
and
we have arrested and my lord
swim free.
And we would like to even forfeit because those equipments or vehicles which are being used for transportation of coal. Because under the MMDR Act, what is happening, my lord, we will come before your lordship in one of the cases, my lord. What is happening is that the truck or dumpers are being released on Jimma. Because under the MMDR Act, it says that if the equipment, etc., is used for mining,
yes.
then it has to be forfeited
Yes.
and auctioned, my lord. So they can't be released on Jimma, my lord. We will be challenging some of the orders because it is not a case of violation of Motor Vehicle Act. It is not a case of violation of.
Yes.
So we will auction if we are successful in auctioning few dumpers and coal trucks, my lord. That will send a signal, my lord. We will be challenging some of the orders before the lordship in separate proceeding, my lord. That issue has been flagged by the concerned deputy commissioner and also SP, my lord. It is submitted that SIT is now your lordship will see the charge sheet paragraph 6, my lord.
Yes.
Paragraph 6.1, charge sheet filed on 27th April. These are the matters after your lordship's hearing.
Is this a Thangsu incident?
A Thangsu incident.
Or is it across the board?
Yes, is a Thangsu incident and across the board, my lord. I'll take your lordship to each of the case, my lord. It's a brief. Details are there in the annexure, but we have prepared a brief, my lord. Charge sheet filed on 27th April against mine owner and operated wide Clariot PS case number so and so. Again, headman also, my lord. Headman White Clariot PS case. Now 6-point charge sheet against headman White. So these are the charge sheets which we have filed after your lordship order in the Clariot PS case number. Now, my lord, paragraph 7, Thangsu incident, my lord.
Yes.
It is submitted that Clariot PS case number 14 of 23 in FIR registered in connection blast incident on 5th February. Thangsu, in the second supplementary charge sheet was submitted against the arrested accused person on 6th May after receipt of post-blast investigation report of BDDS Meghalaya Police and prosecution sanction from District Magistrate. It is submitted that Clariot PS case 100 and section 21 of upon joint inspection falling persons of identified illegal mine have been arrested.
Which mine is this?
These are, my lord, those are, if your lordship will see a FIR number. This is under MMDR, my lord, only there because about 98 FIRs have been registered. 98 FIRs, my lord.
People name here, they all look like laborers only.
No, my lord, no, if your lordship will see, kindly see the details, my lord. It starts from page mine owners, Sardar. If your lordship will paragraph page 12, kindly come to page 12, my lord.
Yes. 100, where's 100?
Coal mine manager Sardar, namely so and so. His statement recorded. He is forwarded to Honorable Court presently judicial.
This is PS case number 3.
Yes, my lord.
100 one you referred to.
Yeah, written FIR on 5/1.
No, 100. Come to 100. 100.
Case number 100. Yes, 100, my lord, is at page
47. 47, yeah. 9 laborers. Yes, this is the one. This is the second place where they
yes, and then there is just
no mine owners were found.
No, charge sheet against the mine workers, and then your lordship.
FIR lodged by so and so at the magistrate during physical site inspection. No mine owners were found. So then we have to take steps here.
Yes, my lord. We will take a step.
These are laborers.
No, these are the laborers who were found at that, and the mine owners also, my lord. 100 is, if your lordship will see 100 because
page 47. Yes,
page 47.
It's fine. Yes, okay.
Yes. This is supplementary charge sheet, my lord.
Yeah, no mine owners was found. So that yes. Right. Yes.
So if your lordship will see the data at page 10, my lord, that will be.
So you mean to say that all the cases have been registered, charge sheets have been filed?
Yeah, charge sheet is, if your lordship will see page 10 foot of the page, data is there, my lord.
90 FIRs.
If your lordship, as on 28th May,
extraction
90, registered is 90, illegal transportation 22, theft seize 4,
two explosives.
Yes, my lord. And that report is also there, explosive report I have seen. So this ongoing process is going on, my lord. And so far as compensation is concerned, my lord, if your lordship will have that compensation, 17 persons we have, page 7, paragraph 12.
Only from Assam, Meghalaya.
Yes, and for Nepal, we are trying to contact and we are not getting the relatives, etc., my lord. Even we have been writing repeatedly, Annexure B.
16. Page 17.
Page 7, my lord, page 7. Paragraph 12.
Yes.
And we have approached again Ministry of External Affairs at page 63. 62 are those letters, my lord.
Page
62 and 63. Page 62, my lord. So the actions are, your lordship has seen number of FIRs, committees, we have been taking action and there is no let up in our efforts.
only one thing that there's no mention is in the course of investigations by this SIT.
Yes,
What
ma'am.
about the officers who are complicit in the, in enabling this, who do not, who are diligent or not diligent, negligent in the duties? See what happened in Townsville,
against
yes.
the
That
office.
is the officers. Now, none of them have been named or anyone has been mentioned at all in your report.
We'll file the status report because SIT.
Because then we have to. You can do one thing. You can file and seal cover the officers of which you've taken, which who are competent, who are.
If your lordship will see the previous report, if your lordship will kindly see the
officer, they have to be by name.
Yes,
who was
my
on duty at that relevant point of time near the Thangspo area in East Jante Hills, from who under whose watch this thing happened.
If your lordship
And
will
so-
just kindly see, I've got kindly see my report of 24th April, my lord.
Yes.
For the first time, my lord, at page 24th April in MCPIL report, my lord, for the first time, my lord, your lordship will find entire structure has been dismantled. All local, if your lordship will see.
No, the transfer is not the transfer
Because-
that you have mentioned here. It doesn't mention which context.
And as
It's a
many as
statewide transfer.
159. But I understand, my lord, that whether they, because
Now,
two-
who were the officers who are
Posted there,
supposed
posted
under whose
there.
watch
Yes,
it
yes,
happened? Now, have you
Yes.
taken any action against them?
these are the two, they were, I
Have you
can
drawn up
see.
department proceedings against them? That if it happened that district middle officer was there, was anything done
We
against him?
we will take steps, my lord.
She set an example. But
We'll-
if the officers are left and you only laborers are caught,
No, we have,
no purpose will be served.
we have caught the laborers, we have caught the
laborers-
landowners, we have caught the sardars
Yes,
also.
the Sardar, landowners,
In fact,
laborers,
some of-
but officers who are, you will say complicit in,
we will-
facilitating this kind of illegal
No, your
mining
lordship is right. Ultimately,
and transportation.
Yes, my
in
lord,
two
you-
parts.
or your lordship
nothing
is right.
against them,
Action
they
has
will
to be
scot
taken
free.
against the concern. That I quite see what is falling from your lordship.
Anyway, we'll pass orders.
Yes, ma'am. Yes, ma'am.
So since it takes some time.
Give me check.
Item number 2, hearing.
Who's the penal governor of Assam? Yes. Was it for today? Yes, Mr. Deb.
They were to file an affidavit, but my senior informs me that it's not required to be filed, Lordship.
Which affidavit?
There was
on the last occasion, Your Lordship directed to place to my Lord documents. That documents are already in the part of the record, my Lord. Your Lordship may kindly see
Yes.
the interim order passed by the Honorable Guwahati High Court. That was one of the
Where is
documents.
that?
Page, my Lord, 310
Of the petition.
of the compilation.
compilation.
Compilation 1.
What's the compilation? Compilation 1.
it's in 2 volumes.
There are 2 volumes, my Lord. Part 1. This compilation was not, which means
This was made by you.
by the
Lordship,
petitioner.
this is the compilation of all the pleadings from all the parties. Lordship.
That,
Where is the?
page 310, my Lord. The order is at operative portion at page 311. Although, my Lord, there was no, my Lord, relief sought against the state of Assam in the bail petition, and one averment only there was in one paragraph. But as per the direction of the Honorable Court, we have taken up the matter seriously.
See, because there's a PIL, it's not
Yes,
adversarial.
we have
So
taken
just
up
to
the
try
matter
to
very
come out to
seriously,
figure out the
and
truth. In the sense that because that Assam police had taken up investigation,
Yes.
and so what happened after that? So that is
My
why
Lord, only because of this interim order, we could not proceed further. My Lord, there is a criminal petition filed by the respondent number 14.
criminal petition for quashing.
Yes.
For quashing the FIRs.
And what happened to that?
There is an interim order, and that petition is still pending, and interim order
This
is
the criminal
continuing.
petition was in the bail. Or is this under criminal petition here?
Page 301, criminal petition 112/2022.
At what stage is the criminal petition then?
Still pending, my Lord, this one. There is an interim order, and the interim order is still in operation.
For quashing of the FIR, my lord.
Yes, yes.
Yes.
Criminal date investigation, the interim order is still continuing.
Interim order is still continuing, my Lord.
Since 22.
Only because of this interim order, further proceeding has been stalled, and we could not proceed further. Although sufficient materials has been found against the respondent number 14, and
Yes.
direction of this Honorable Court, we have complied with.
Which is the other document?
Other documents, my Lord, did a report that, my Lord, Your Lordship find that compilation part 2,
643.
page 644.
Second copy, page 644.
644, compilation part 2. This is a letter dated 15/3/2023. This is the report of a field verification,
644.
644.
Yes.
With reference to the letter cited above, in response to the order passed by the Honorable Meghalaya High Court dated 2/5/2023 seeking some information inter alia, verification by State of Assam to indicate whether it was possible for Joyma to purchase such quantity of coal from alleged open market in Beltola, Assam. Accordingly, a field verification was conducted by me along with Inspector Swencho and Inspector Swencho, Assam at Beltola area of Guwahati with a view to gather information on the point as ordered by the Honorable Meghalaya High Court. During field verification, several coal depot dealers have been visited, and on being equipped about feasibility of the dealing of huge quantity of coal covering the period from 2021, it has been revealed by owner of Monu Gupta Coal Depot, Mr. Monu Gupta, manager of Surinder Joint Coal Depot, Mr. Rahul Gupta, manager of Binod Jadab Coal Depot, Mr. Prakash Sharma, manager of SN Sharma Coal Depot.
Okay, just send them read after.
And thereafter, hence possibility of dealing of the huge quantity of coal was not feasible on the part of any of the coal dealer located at Beltola area. In case the demand of large quantity of coal by any customer, which happens in very rare occasion, the coal dealer have to be procured from the Nagaland only. This is the report.
Yes. So statements are recorded also.
Yes, ma'am.
Yes, Mr. Dev.
Lordship, the sum and substance is, my lord, that the respondent number 14 has exported, Lordship, about 2 lakh metric tons of coal from Bangladesh to Bangladesh through Meghalaya, Lordship. And it is our allegation that all this entire coal which he has exported has been extracted illegally within the state of Meghalaya from this Nongal Bibra and other sides of South Garo Hills. Now, Lordship, right from the very beginning of the PIL till date, my lord, he has relied on e-way bills, which he says, my lord, are sufficient proof to show that he has legally obtained the coal. Now, one part of the matter, my lord, is that these e-way bills are all disputed. The economic offences wing of government of Assam has lodged multiple FIRs. The one that has been stayed is one of the FIR, Lordship. There are other FIRs also which are part of the compilation, which, my lord, I personally don't know whether those have also been stayed or they are.
Those are also stayed.
All the multiple FIRs were lodged.
So even the ED, the enforcement has been FIR have been stayed also.
Lordship, yes. Superintendent of taxes had lodged FIRs. Economic offences wing has lodged FIRs. These are on the e-way bills. The primary allegation there was, my lord, that the respondent number 14 is essentially indulging in circular trading, creating.
What circular trading?
Lordship, what he is doing is that he has 3 or 4 firms which are more or less controlled by the same entity under different
shell companies. Yes.
Shell companies, circular
Yeah.
and he is basically, Lordship, without actually physically purchasing the coal, without any physical movement of the coal, what is being moved is the papers, Lordship. One company gives it to the other company gives it to a third company, the third company gives it to the present respondent number 14, and respondent
ultimately transports the coal to Bangladesh.
Lordship, yes. And
who ultimately transports it?
The respondent number 14 exports it. Now, Lordship, already this honorable court has seen and observed that this is nothing else but circular trading, creating a fictitious chain of supply without any actual coal being, Lordship, transacted. That is one part of the matter. Lordship, the other part of the matter is that there is no weighbridge record, assuming that he has bought this coal from a different state. Lordship, in India, legal coal is not available in all the states. There are only regulated mines, Lordship. This is coal, major mineral. It cannot be brought from any random, Lordship, mine. It has to be done under a proper license issued by the central government. Now, in that regard, my lord, that there is not a single document of either showing the factum of transport that this coal has entered from X state to the state of Meghalaya. Neither, my lord, there is a single document to show that that out of the entire 175 to 2 lakh metric tons of coal which he has exported, there is not a single document to show which mine he has, my lord, sourced that coal from. And that is there in the rules, my lord. Now, the difficulty here is that the state government as well as the customs, unfortunately, are, my lord, not. They say that they have no authority. As long as they check the e-way bill, that is sufficient. But in my humble submission, my lord, that what is required is the source of the document of the coal, because that document, Lordship, under the MMDR rules itself, carries right from the mine where the coal is mined all the way till the point of export and the final use, Lordship. It is carried forward irrespective of the number of hands it has exchanged in the way. But there is no document, Lordship.
Yes.
So my humble submission is, in such view of the matter, Lordship, this honorable court has been pleased to grant an injunction against the respondent 14 from dealing with any coal without the leave of the court. And till date, Lordship, he has not been able to satisfy.
Yes. The source of the coal.
The source of the coal, my lord.
Yes. Let him finish.
And Lordship, that is one part, Lordship, that there is no document to show the source. The other part is, Lordship, that there are some lapses on part of the authorities also. In as much as, Lordship, that number one is that they wave their hands saying that we have no authority to check. That, my lord, should not be a not be the approach by the government, Lordship. It is natural resources, it's their resources, public resources which are being exploited. And the second part is even in the records of the respondent, he says that I have exported X amount of coal. Transport department says I have given challans or checked the e-way bills for a different amount of coal. Customs says that even a higher amount of coal has been exported, Lordship. But where the coal is coming from is not known to anyone. And in the meantime, Lordship, another plea was also raised.
So this was between December 14, 2021 to May 2022,
Lordship,
the space of 6 months.
Lordship, yes.
1,74,725 metric tons.
Lordship, yes.
Yes. Yes.
Multiple permissions were given to him by the DC.
This order 2/5/2023. Yes.
DC had given blanket orders allowing him to take the dumped coal. What had happened is, Lordship, they had, in my humble submission, devised a plan to dump the coal in and around Bagmara and Gaswapara. And from there, Lordship, that dump coal is ever increasing. And thereafter they said that, my lord, that they have bought the coal entirely from Beltola open market. And that also, Lordship, this honorable court was pleased to direct the government of Assam at the DG level, SP level to conduct inquiry. And their report is very clear, my lord, that not only he but none of the traders there could have purchased any coal of such large quantity, my lord. And Lordship will see 1,75,000 metric tons, Lordship, 74. Thousands of trucks must have gone. There is no record, Lordship, nothing at all.
So since 2nd of May 2023,
Lordship,
that the order of this court,
Lordship,
in a way, it's already recorded the amount exported and that the blanket permission allowed by the Deputy Commissioner over 1 month.
Lordship.
And then the last part is that
thereafter there is an order not to allow him.
Yes, no coal should be allowed to export it.
Transported or dealt with without the leave. That is in operation till today.
But now, one operation is that even for any other exporter also, without the source being indicated, can there be any export?
Lordship, that because why the difficulty we are facing is there are two authorities, Lordship, who are at the location.
One of exit.
Lordship, one is the transport state government having the DMR check gate and the transport check gate.
Yes.
They are, my lord, saying that we don't have any authority or it is not within our purview.
Yes.
And customs, which is the final point of exit, Lordship, simply says that once we get the TP or the e-way bill, that is all that we look into.
Yes.
And their own records are also not tallying, Lordship.
So now it's remained in limbo in the sense that by the next order, I think, 17.5, that report was circulated. That report placed by, what is your name?
D.K. Sharma.
Mr. D.K. Sharma.
Lordship.
That page 644.
Lordship.
And to file.
Thereafter, my lord, the respondent filed an affidavit taking exception to that report, saying that this was a biased inquiry or otherwise.
Yes. No, the thing is that now this court wanted the appropriate explanations to come, which has not come till date.
Lordship, please.
And all the investigation is held up because of the interim orders of Guwahati High Court.
Lordship, in my humble submission, that investigation, what would follow under the criminal law is, my lord, per se not the subject matter here. Lordship, those FIRs have been registered under 420, 460.
It has a bearing, but Mr.
Of course, it does.
Doesn't mean it involves the same
it does.
subject matter issue.
It does, Lordship.
Whether he could have obtained that coal from Beltola, because when he exported it from Guasupara,
Lordship,
like to Bangladesh, that 1.74 lakh tons. Now, the statement was that this is coal from Beltola, bought from open market in Beltola, and permission was given to Deputy Commissioner for 1 month.
Lordship.
That one was without any reason, extended for 6 months, and 1.74 lakh tons meant.
Lordship.
And so that's where the mystery lay, like where the coal come from, how the EVA bills procured, what was the manner adopted by the method by the officials in in verifying the source of the coal or allowing you to transport it. That question remains till today. And now, if FIRs are filed by the enforcement or by even with regard to the other order which was shown,
Lordship.
now those also have been stayed.
Lordship.
So nothing could progress.
Lordship.
So you want to fix any liability, responsibility, it remains in limbo. So what is the way out then
Lordship.
in your PIL?
Assist your Lordship on this issue. If Lordship will see the prayer of the PIL petitioner in this matter, my Lord, because this is an old matter of 2022, my Lord. Their prayer was to, because when the transportation was taking place, my Lord, rules were not in place, the process was not in place. Pursuant to PIL, my Lord, their prayer was, my Lord, to issue direction to the government to frame the rules. Lordship will have kindly page 53, my Lord. Yes, my Lord. That the page 53 of the PIL, my Lord, if Lordship will PIL 8 of 22, direct the concerned respondent to recall and withdraw, resign the permission to export via order dated 29th April. So first prayer is to cancel the export order, whatever is permission is granted by the Deputy Commissioner, South Garo Hills. Direct an independent commission of inquiry or independent agency to immediately conduct proper assessment and verification of standard and dumped coal in Gaswa Para, my Lord. Third is, my Lord, direct the concerned authority not to allow the export of coal by JAMA and direct to auction the standard coal, my Lord, FIR, my Lord, and then F, my Lord, Chief Secretary to appropriate legal action, and, my Lord, the last is revenue loss, recovery. These are the 6 prayers which petitioner has played, my Lord. Now, in affidavit filed by the state, my Lord, because the affidavit filed way back on 4th July 2023, the standard operating procedure and have been placed, and now rules are in place. Now what is his grievance is with regard to one consignment of legal or illegal coal transported by respondent number 4 from 14, sorry, respondent 14 from Assam to Meghalaya or Meghalaya to. So this issue is also, your Lordship has rightly said, is subject matter of FIR which is pending in the Assam law. That in PIL, whether these issues can be examined and looked into once the legal recourse which has been taken by the Assam police against the respondent number 14, and if they find that he has done illegally, Lordship may revive the PIL, because, or your Lordship may, because ultimately your Lordship is.
See, another thing apart from respondent 14. Now the thing is that what has been revealed by this PIL,
yes,
is that the entire process of transportation,
that is what
verification, that is what they're, I mean,
allegation
glaring, I mean,
no, my Lord, there are 2 aspects which the PIL petitioner has highlighted. One is that
whatever maybe
custom authority
readings are not in order, or maybe the frame will not be relevant any longer, but
as is not frame
is a PIL,
yes,
and so the court has to look into whether now you have
now question is also
which now you say the SOPs are now.
The question is also for your Lordship's consideration is that it is a case of violation, assuming that there is a violation, my Lord. I admit that without, if assuming there is a violation of law by one of the person in exporting the coal, my Lord, without admitting either way, my Lord, whether there is a violation or not, we have taken action. We have seized, auctioned also. That person has come against that order. The respondent number 4 that has been dismissed.
Yes, coal already been auctioned.
Auctioned, my Lord. We have taken, and FIR is also going on, my Lord. That is a separate proceeding is going on. Now the question which falls for your Lordship's consideration, which are twofold. One, how do we address the prayer of the PIL petitioner in this matter, where the complaint is directed against one individual? Against him, the criminal cases are going on in Assam. Criminal cases are also registered here.
Yes.
So it's a case of individual. Now, larger issue, my Lord, in your Lordship is already seized within Sumoto PIL. Larger issue, your Lordship, and Justice Kataki is already seized with the any violation of coal. So this is a small segment. That is why these matters are connected to Sumoto PIL. They were one individual way back in 2022 allegedly violated, and as per the petitioner, coal mined illegally from Meghalaya to Bangladesh. The respondent of 14 cases that no, I have purchased the coal from the depot in Assam, and for which FIR was registered in Assam. He is having his own criminal cases going on there. He is facing criminal case. Whether in the PIL, my lord, this question would your lordship, because if your lordship will return the finding either way, either in favor of the petitioner or against the state, or my lord, those criminal cases are going on. My lord, in PIL, in my humble submission, your lordship may not return any finding on the criminality or non-criminality of the action. Your lordship,
not looking into that.
so
You're not passing orders on
the criminal.
The
Now,
only thing is that
so now the
something
second aspect.
is wrong.
Second aspect.
Something is wrong. So what goes to the court,
So, no,
and respondent 14 has been like the example of what has been
is wrong.
Is
wrong.
happening. That's
Yes.
the only thing.
Yes, that
If
your lordship is right.
Brought by a public.
I'm not.
And find that this is happening, then we have to pass orders.
Yes, my lord, your lordship.
to hold someone
Your lordship has.
accountable that this thing doesn't happen.
Your lordship has been
And
passing
if you
the.
have SOP, then you adhere to it.
Yeah, your lordship has been passing the orders in suo motu PILs for ensuring that no illegal coal mining takes place in Meghalaya. Justice Kataki is also reviewing it. Now, I am only concerned with the PIL, this 22 or 22 and 23. In this PIL, the only issue, in my humble submission, is whether this person has transported the coal illegally from Meghalaya to Bangladesh or from Assam to Bangladesh, my lord. And that issue, your lordship has rightly said that it's subject matter of FIR both in Meghalaya as well in Assam, my lord. So therefore, there are overlapping issues between the criminal cases which are pending in Assam and Meghalaya and the PIL, my lord. Now in PIL, so far as the larger issue is concerned, your lordship is already seized with the larger issue, where lordship is continuously monitoring whether illegal mining is taking place. Your lordship is directing action, and Justice Kataki is also looking into these aspects, my lord. So therefore, only
You pray that you close this PIL.
no, I'm not saying that your lordship may continue the PIL, but ultimately your lordship has said that
It's a futile exercise.
no, your lordship, no, what your lordship
Are you
has said.
saying that?
No, I'm not saying that, my lord. What I'm saying is that, my lord, the larger issue which my friend has raised can be part of your lordship's exercise in suo motu PIL, which your lordship is already undertaking. So far as the
So
criminal,
meanwhile, what will you do with respondent 14?
respondent number 14 is ultimately your lordship.
Be subject to the criminal proceeding.
Subject to criminal proceeding. Subject to criminal proceeding, my lord. That is what we can do.
Yes, Mr. Deb.
Lordship, if that injunction, which is Lordship, two parts. One is, my lord, personally, I
An
have
injunction from this court against the respondent 14 from doing any business in court
Lordship, yes.
or exporting any coal, right?
Lordship,
Yes.
yes.
Now
That-
he's aggrieved with that.
Lordship,
Now
yes.
he wants that ban to be lifted.
Lordship.
That's the only thing.
So
Yes.
what I am praying, my lord, two parts. One is, Lordship, that I have nothing personally against the respondent 14 or any other trader or exporter, my lord. As your lordships have indicated, this is something that has been brought to the notice. He is just an example. Lordship, it is his misfortune that he is the example, but that this is what is happening across the state. Lordship, having said that, my lord, my humble submission is that the injunction order was passed on being prima facie satisfied that there is something amiss. Lordship, that order may be made absolute, is my first submission.
Which date is that? 26th?
Lordship,
May.
Lordship,
First
11/6, 11/6/23.
Yes.
Let him satisfy, my lord, that he has enough bona fides and
My
enough
lordship,
legal sources.
my lordship,
If the honorable court grants him leave, he can
Yeah.
deal it accordingly.
Yes, Mr. Bama.
my lordship, first and foremost, my request is that the injunction order was not passed because something was found illegal against me. It was just because my counsel was not present that day. Arguing counsel was not present. The petitioner has been misrepresenting that fact time and again, and in my all my affidavits, I have specifically mentioned that the injunction order was specifically given because my arguing counsel was not present that day, and the proxy counsel wanted a short accommodation for filing the documents, and the honorable court was not kind enough, and for that particular date only, they stated that okay, no coal should be exported, and that order became an embargo in my legitimate business. And second thing, wherever the Assam, state of Assam has stated that they have filed affidavits, I have filed counter affidavits to which none of the rejoinder has been filed from the state of Assam. So not only their affidavit should be taken on record, they should be read along with my affidavit or my counter affidavit. As far as the report of state of Assam was that there was no coal in 2022, I have substantiated those facts through RTIs and through data which I could accommodate as an individual from the state's sale tax department itself. Okay, so that clearly proves that there was enough coal during which we procured the coal. We procured only around 1,40,000 metric ton of coal, but there was more than 1 million metric ton of coal available in Assam during that same period in which the state of Assam is refusing. And as far as the stay on the FIRs is concerned and criminal proceedings in Assam is concerned, my lordship, after extensive hearing in the court, it was not an interim order which was passed on the first day itself in the courts. It was after extensive hearing and detailed orders were given that why the stays were granted.
So then why you're not pursuing your criminal petition before the Guwahati High Court?
My lordship, I have been pursuing those criminal petitions as far as certain GST audits are going on, my lordship, and GST proceedings are ongoing in those cases. Once those GST proceedings are over, like most of the relevant years are already over, and none of the year have created any demand or have set aside my any of the invoices which they allege. So like one financial year is left out. They have alleged like for 6-7 financial years, the state GST department has alleged that there have been certain anomalies in the trading of my business. But as far as if you connect these two cases together, their case was there was no physical coal. Your case is there was no physical coal. So physical coal was also there, invoices were also there. So none of the thing is like as alleged by the petitioner that these two things are in scenario, my lordship. These two things are like, if you separate these two proceedings, if you give a finding that no, there was no coal, like as far as in those FIRs, they mean to say that there was no coal, but they seized the coal in Assam. They have my seizure list, which they hide it from the court. They continued with the investigation, my lordship, even after the stay was granted. They continued with the investigation for more than 2 years. That was again reflected in the judicial orders, my lordship, which I have annexed in my affidavit, that they continued with the investigations despite the High Court stay order. So the state of Assam is directly vindictive against me. That I have already told that yes, the state of Assam is vindictive, and for some reasons which we do not want to, which are not a part of this PL. I just want to state that either way, if you take it that okay, the allegations which are there in Assam, if they come true, then as per them there is no coal, but physically coal has been exported, my lordship. So it is
Okay.
for the petitioner to.
Right. You do one thing. You just file your sworn note submissions, and we'll close the matter.
State is not required, my lord. Our stand is very clear, my lord.
Even the triple MCR rules which they have notified now, my lord, does not per se address this issue.
You have challenged that.
Submission,
You
yes.
challenge separately, don't.
You make your notes on submission, Mr. Bama.
Yes, my lordship.
Refer the affidavits, and even if
Yes,
you
my
have to
lord.
conscious to refer the affidavits.
I'll do it. I'll put it on.
Yes.
They are both connected.
I'll
my
file
lord.
a combined.
Yes.
This larger
when
issue,
can
your
you file
lordship.
it?
3 weeks, my lord, because there's a voluminous record. I have to.
Oral arguments have been concluded. Parties pay them allowed to file points and submissions, written notes and submissions. List after 3 weeks for filing of notes and submissions. You kindly file even.
Yes,
Yes.
Obliged.
Lord, I beg to mention an unlisted motion, my lord. There's some urgency. This is I'm the deputy CM, my lord, of CM of Malayam. Now there has been appointment of an acting CM, my lord, which is dehodes the act, my lord. Acting CM dehodes the act, my lord.
Yeah.
So, my lord, slightly urgent. If your lordships can have it
Today?
today, my lord. Very short grounds, just two grounds.
Tomorrow, my lord.
Yeah,
There's some urgency, my lord.
I'll take
Just two grounds, my lord.
instruction in place.
Just two grounds, my lord. Firstly, my lord, the order passed by the executive member Ilaka is incompetent because it's signed only by one EM, my lord. So on that itself, my lord.
My lord, the order was passed on 21st, my lord, by the full executive committee, my lord.
This is similar to
Lordship, if I can just, my lord, I have filed a caveat. I have just received a copy. If I can just point out one thing, my lord. So for these issue of my lord, the same chief is concerned. Earlier occasion, my lord, two occasion, my lord has recused from that.
See, I think that is the, you see, my recusal, I think that has to be reviewed, because I never appeared for this person. Only thing that his uncle was my client once upon a time, and that was the City Council. I don't know whether you avoid my court or something. They said because he appeared, because I was and I never appeared for that uncle also, even election matters also. But then also because just to not to bring in, but then if this is the way,
Madam, just from the record on matter. With due respect, madam. Order 15/3/2018.
I appeared for this person.
Yes.
As what?
Madam.
Let's see.
Because of order also.
No, then doesn't matter if that is what. But if you see, I appeared for I was the. Yes. No, I was
in WPC number 9 of 2018.
recusal order.
These are recusal order I am placing, madam. But the order lordship appear in the WPC number 8 of 2009 of 2018. Lordship prepare for petitioner.
Okay then.
Because of that, otherwise we have no objection.
You put it for the other bench.
No, my lord,
Not my matter. My matter is different.
lordship, if I can only thing, my lord, since your lordship cannot take up the matter, this has to be, my lord, my understanding, your lordship, my lord, back to what your lordship says, has to be placed before the Chief Justice, my lord, for assigning.
No, it'll be placed for another bench, not me. Finished. Let it come up.
My matter.
Yes. Otherwise, you can't have this bench hunting. Yes.
Lord, I pray for urgent listing of one matter, Lord. New
It's
matter.
already filed.
It's filing. Be filed today, my lord. If can be listed tomorrow. We have been prevented, my lord.
What is the matter?
We have been prevented, my lord, by the district council from leasing our market, my lord.
Where is this?
Market is there in Right Noshkan, my lord. If my lord can recollect, this is a matter where I was suspended as a Sardar. Then subsequently, my lord, there's a stay by the district council. The other side files before this honorable court, and this honorable court has remanded the matter to this AM, my lord.
Right.
While the matter was still pending before this AM, the district council now says, my lord, that we cannot lease the market, my lord.
Yes.
Tomorrow. Be listed tomorrow.
I'd like to mention item number 71, Your Lordship.
Yes.
Pray for 2 weeks' time, Your Lordship. Mr. Day is not
71?
Yes, sir. Yes, Your Lordship.
Why 2 weeks' time?
Mr. Day is not well, Your Lordship. He's having
Then this is just for you to reply, correct? What's it for? You've heard this how many times? Where's Mr. Deb?
It has hurt a number of times.
Not too many times. I think that we are complaining too much.
Exactly. Lordship is gracious enough to give him number of times.
As you withdraw it? Okay, after 3 weeks?
2 weeks.
Yes, those matters part heard. Adjournment has been sought on the ground that the Arguing Council is indisposed. Like in the interest of justice, let's matter for 2 weeks. Yes.
Much obliged.
May I please, Lordship? Lordship, I beg to make a mention of item number 79, Lordship. Lordship, I'm praying for 2 weeks' time. Lordship.
Matter is fixed for hearing, Your Lordship.
No, yes. What? You have any objection?
No, Your Lordship. This is the first day.
Yes. No urgency. Yes, 2 weeks.
I do oblige, Lordship.
Oblige, Your Lordship.
Just make it quick. Yes. One thing was the Changreso. Where's that, Ms. Changreso? You tell you, Mr. Dhar, you kindly please order that 18 order because
Yes, Lordship.
yes.
I beg to mention item number 77, Your Lordship. It's a joint request
Lordship.
Yes.
after 2 weeks, Your Lordship.
Pleasure, Lordship.
Your Lordship, I beg to mention item number 81.
Contempt matter.
Your Lordship.
Yes.
My lord, we have already filed counter affidavit in this matter, my lord. Rejoinder has not come in this matter.
You
81, my
have
lord.
rejoinder?
Your Lordship.
Okay, yes. 2 weeks, yes. Yes.
May it please Your Lordship, I beg to mention item number 78. Your Lordship, I'm praying for 2 weeks' time.
This is also regarding the same school, Your Lordship, 79 and 78,
79?
and which was adjourned. a little
79
while.
just now?
Yes.
Yes, this together with 78.
Yes, Your Lordship.
This together with some. So this,
Like,
the prayers also this. Yes.
Please, Your Lordship, I beg to mention item number 72, Your Lordship. I pray for 2 weeks' time, Your Lordship. No objection, Lordship.
Your name?
Ithaba.
You just record the name.
Please, Your Lordship, I beg to mention item number 74, Your Lordship. Lordship, joint prayer, Your Lordship. 2 weeks.
This is a matter regarding?
This matter pertains to land acquisition, Lordship, aggrieved by the rate of enhancement of the land compensation.
Okay, yes. 2 weeks, yes. Yes.
Please, Lordship. Lordship, item number 73, Lordship. Here, Lordship, regarding that judgment, Lordship. I already took instruction, Lordship. It is against the stay order, Lordship. But, Lordship, since I was in bereavement, Lordship, today only I joined. So I'll just have a talk with my department and...
Up to 2 weeks, yes.
Lordship, interim may continue, Lordship.
Interim order, we need to continue. Like that.
Daily list item number 1.
Here, please, Lordship.
Yes.
Lordship, this matter, this is that land acquisition matter, Lordship, and the repetition is
which
here.
one?
Item 1, 2, and 3.
Now 1, 2, and 3, Lordship. Lordship, now pursuant to the division bench order, Lordship, the repetitionist has approached this honorable court, Lordship.
What division bench order?
Lord, if Lordship
Liberty
will
was
recall,
given, Lordship.
I would recall that in Lordship has dismissed the petition filed by Fidan Thava and others.
Okay. How is it connected to this one?
And they are saying they went against the order of your Lordship before the division bench. So the division bench said that you have not gone to the writ court. First you exercise page
Or you challenged the order, you took leave to appeal.
Lordship, leave to appeal, and that liberty was given, Lordship. So
2720B, my lord, we would like to file preliminary objections. 27A, the Lordship will have.
Lordship, 27, page 27, Lordship.
The order of the
Yes,
division bench.
Yes, Lordship.
Can you bring 27? Yes. Yes.
And my lord, we would like to file our objection as to the maintainability and all those aspects in all the 3 matters. And in division bench, my lord, if I succeed in if
no, then we'll put this matter in cold storage.
Lordship.
That is
Lordship, may issue notice, Lordship.
Yeah, we issue notice, of course. Heard Mr. Keita Khan, and Council Petition issue notice. Then Advocate General with our colleague is present on behalf of respondents.
1 to 6.
1,
2, 6, my lord.
1, 2, 3, 4, 5, 6. And Dr. M. Mozika. 7, 8, 9.
8, 9 notices will.
Yes, for 7. With so no further notice required in these respondents. Notices to issue to the respondents 8 and 9 within 3 days. Stop. It is submitted at the bar by the counsel of the petitioner that the matter is in substance connected to what is that case?
WA number 7 of 2026.
Number 7 of
2026.
wherein the division bench had directed the petitioner to first approach this court. No. What happened? You went and filed an appeal.
He filed the appeal, my lord. He filed leave to appeal, which was rejected. And it was withdrawn.
Wherein the order of this court passed in
Lordship in
now BC number.
I'll just
475 of 2024.
Have been put to challenge. Stop. Mr. Tidhar submits that though leave to appeal was sought to against the same order passed in WC 475, the division bench by order dated 9/4/2026 directed that the
permitted the petitioner
approach the single bench. As such, the matters appear today. In this view, the matter this is matter after 3 weeks awaiting outcomes from the matters pending before the
division bench.
Item 1 to 3.
1 to 3 is connected.
Same order in.
Supplementary list, item number 1.
Yes.
Lord, this is a tender matter, my lord, wherein supply of fresh vegetables and
Fresh vegetables.
yes, fresh vegetables and non-veg item, fresh non-veg item was called for. The bid was called on 28th of March 2026, and there were 4 tenderers had participated, and from the technical bid when it was opened, it appears that 2 of them were not qualified and 2 were qualified, out of which myself was qualified and the respondent number 6. Now thereafter commercial bids were opened. My lord, so far as the technical bid is concerned, as per the bid terms and conditions, there is a criteria that for last 3 years financial years the participant has to be having had the experience of
Engage same business.
not only same, the value should be not less than 40% of the bid value, and it appears that since he has been qualified in the technical bid, it appears that he submitted some papers. We made verification on our own individual capacity, and we have come to know that the JNV schools in Mizoram, they do not even have such big tenders. Their earnest money itself is of rupees 10,000. So we made an RTI application, but that reply is awaited. In the meantime, we filed a representation before the tender authorities saying that any papers, if to support and justify qualification in the technical bid so far as the commercial experience is concerned, that either may be manufactured or fake, and therefore an inquiry should be made. Now
Where's the tender clause that says that? Which page is the tender?
in the NIT, that will be at page clause 6, clause 7, page 58. I'm sorry, my lord, page 55.
Yes.
Clause 6.
Technical bid. Yes. Where's that condition? Past experience.
6D.
Yes, 6D. Past experience. Minimum 2 years experience out of last 3 years, 22 to 25, for supply of fresh ration items, that is fresh veg, etc., and fresh non-veg I'm just cutting it down. In the particular state of jurisdiction of advertised tender, copies of relevant and authenticated documents, indents, acceptance letter and contract documents, etc., supporting the same issued by so and so has to be.
Your case is that who's the respondent who was settled with the contract?
Settlement was not done.
L1
Respondent number 6.
Yes.
Respondent number 6
experience.
does not have the experience, and if papers have been annexed, because it has to be within the jurisdiction of Mizoram where the supply has to be made.
Now, how to substantiate your
Now,
submission?
to support that,
Yes.
when I did an RTI, while awaiting for the RTI, there is a notice board new at page 67 of JNV, it's Mizoram, Thingsul Tlia.
Yes.
My lord, may kindly see, for veg item and non-veg item, the EMD is 10,000 rupees, and they do not have so many students to go to crores of rupees.
Earnest money deposit.
It's an earnest money deposit. What I am saying, even if it is 1%, it is normally 2 or 3% of the EMD. If it is 10,000 rupees, that means the value is not more than 10 lakhs rupees, and it is for 2026-27 when the prices may have at least risen by maybe 10%. But even going by the minimum, so and since I have given an RTI and also a representation, a complaint that without verification don't move forward, please verify, and if it is so, then he is the lowest tenderer, so he is entitled. But till verification, and I have raised a bona fide doubt, especially with the JNV notice. In my respectful submission, the respondents' authorities, they should not be moving forward with.
I have the instances I've placed.
Yes.
And
But this is purely on the basis of some kind of assumption, my lord. We have documentary evidence. So kindly
What does
see,
the instruction say?
first 3 pages, my lord. After that, lots of kindly see appendix A is
Yes.
written, my lord. So we have written to the principal Navodaya Vidyalaya, my lord, asking for turnover, and they have given a certificate. Next page continues.
This is page.
year?
Appendix A.
Appendix A is the letter, my lord. We have said, we have asked them.
Okay, yes. And next one?
Next one is the certificate given by JNV, my lord, that turnover of 1 crore 50 lakh rupees.
Yes.
This to certify that so and so Bethlehem, Mizoram was awarded the contract for supply of fresh ration so and so Navodaya Vidyalaya for the financial 24-25 for the value of rupees 1 crore 50 lakh. So no prima facie case made out, my lord. We will file an affidavit.
My lord, this also in my respectful submission,
Not
I
only
do
that, my
not.
lord.
It's fabricated.
No. I am not saying that when there is placing
Not only
before the
that, my
court,
lord,
not at
the
all.
petitioner went on to threaten the private respondent to withdraw the contract, and FIR is in file to that effect, my lord.
Who threatened the petitioner?
The petitioner, my lord.
Why your petitioner doing this kind of
I am
thing
not aware of this,
on
my
your
lord.
advice?
Otherwise, I would not have come with the writ petition.
Yes.
So I'll file an affidavit.
My
No
lord,
case was taken.
Till then, if some status quo is there, and let a short date be given, let them file it. My lord, can I ask? Can I request for a copy of these instructions?
Yes.
Can we please, because
Dr. N. Modi I with MSc Jala is present and accept those on behalf of respondents number 125. No further requirements on these parties. Notice issued to respondent number 6, 7, and 8 within 3 days. Stop. The grievance writ petitioner is that the grievance writ petitioner who is stated to be a tenderer for supply of
fresh vegetables and fresh non-vegetarian items.
Items with the respondents is that though the petitioner and respondent number 6 were declared to be technically qualified.
And L1.
Huh?
L1 also.
Technically qualified for supply of the items, notwithstanding the fact that respondent 6 is L1, the technical bit as per the learned counsel, the technical criteria was not met due to lack of experience and stuff. She therefore praised that in the interim that the tender will not be given effect to stop. Next, Dr. N. Mozika, who is present on behalf of the respondents,
1 to 5
will produce a set of instructions / communication dated today, 1st June 2026. I wish other departments are prompt, June 26, and submits that as per the records and information received. The respondent number 6 is qualified on both counts, technically and financially, in as much as he is L1 and is also engaged in supply of fresh rations. Stop. Therefore, submits that no interim orders are called for this stage. Stop. On hearing and counsel of parties on perusal of the materials as placed. Stop. The instructions is directed. The instruction will be placed on affidavit within 1 week, and the matter will be listed immediately thereafter. Yes.
And subject thereafter, in case any interim is, I can apply my. There is some
food for Jawans.
Yes.
We don't want any stay.
That's right. There is something more. There was something more against me which my friend did not test. We have even given a PR bond, I am told. I'm grateful, my lord.
Things are for food. I must go and like.
My date, can it be on 12th?
Yes, 12th.
I'm grateful, my lord.
Item number 2.
May I please, Lordship? Lordship, it's a tender matter, Lordship. The respondent here.
Tender matter?
Yes, Lordship. It's
supply of fresh vegetable also.
No, this is a supply of mixer, grinder, utensils, and
Lordship, various kitchen utensils, Lordship.
Kitchen utensils.
Now, what had happened is, Lordship, I being the company, Lordship, I beat it in the tender, Lordship, floated by the respondent.
What do you manufacture?
Lordship, we manufacture utensils, Lordship. We are OEM, Lordship. Now, what had happened is, Lordship, on 4/5/2026, Lordship, my tender was disqualified without any reason, Lordship. On the technical ground,
How many
Lordship.
tenderers were there? How many bidders were there?
3.
How many were shortlisted?
Shortlisted 3, Lordship.
Okay.
Total there was 6.
Okay. Then what
There are
happened?
3. Yes, Lordship. Now, thereafter, Lordship, they have not provided us any reason, Lordship. Till date, Lordship.
Disqualified technically.
Yes, Lordship. And as per rules 173(4) of the General Finance Rules, Lordship, there should be transparency, Lordship. Even in the GEM portal also, there's a provision that within 48 hours, we have the right to arise if there is any issues regarding. And in their tender bid also, there's time boundation of 2 days, Lordship. Lordship, we were not given any opportunity, and they have not provided us any on which ground our.
Where's that? Where's your? You approach them?
No, Lordship.
Then?
Online, Lordship, since till date, Lordship, no L1 has been declared in these 3 gems. Lordship, bid numbers, that is 7404073, that is for milk boiler, wet grinder and mixer grinder.
70?
Which is in page number 4.
That means milk boiler, wet grinder,
and mixer grinder, Lordship.
What's the value of the contract?
The value of contract is around, Lordship, 2.2 CR.
2.2 crores of mixer grinders.
I don't think.
Is that correct, Dr. Mozika?
It
By 2.2 crores worth of mixers.
Should not be, my lord.
Lordship, total 3 bids are there. One is for the mixer milk boiler, another for the stainless steel floor burner and gas ovens, another for fruit and vegetable washing machines.
That's 2.2.
The numbers are 426, then 45, and then 61, Lordship. Now, Lordship, till date, Lordship, L1 has not been declared, Lordship.
Stainless steel floor. This is also you bid for this also 3.
Yes, Lordship.
And also 4.
Yes, Lordship.
Okay.
Bid number 7404073 and 22829.
Where's the impugn order?
Lordship, there is no impugn order, Lordship.
Then?
There are 3 different causes of action, my lord. They filed 1 petition, that is
for 3 bids.
Formal defects, my lord.
Lordship, on the same date,
That's
Lordship.
That's one only. And I have the instruction, my lord, with regard to others. The three bits, Your Lordship will see 2.1, 2.2, 2.3. Three separate items, my lord. And now in the first bid, the petitioner past performance not complied since.
That means tea, milk, boiler, wet grinder, mixer, grinder, past performance complied.
Since
Yes,
CRAC
lab test
invoice
report not
completion report
submitted.
not submitted. Government NABL lab test report and self-life certificate not submitted. That's with regard to first tender, my lord. Second tender, again, government NABL lab test report not complied since complete parameters are not tested as per the requirement and report does not clearly display the NABL accreditation symbol. With
So yes, Mr. Ghosh.
Yes, Lordship.
Now, number three,
Then
third
why
one.
didn't you supply to him before?
And moreover, my lord, there is a 48-hour window in the GEM portal. They didn't take use of that also, my lord. Now it's not for us to advise them or what is required to be done, my lord.
Lordship, as per the
that we have stated in para 5, my lord, on the next page. The interest of fairness, transparency, and adherence to Mr. So-and-so was afforded an opportunity to rectify and clarify the deficiencies within 48 hours.
Mr. Ghosh, then you withdraw this or will
no, Lordship may come to page number
see
16.
if they given you.
No, Lordship, we have complied with each and yes, Lordship, page number 16, Lordship of my petition, Lordship. In documents required from the sellers, experience certificate, past performance, bidder turnover, certificate request for ATC, OEM authorizations, certificate OEM annual turnover, and additional documents. Lordship, as per the here main document, what is required was past performance, Lordship. Recently, Lordship, which is in page number 32, Lordship.
See now,
I have provided my supply order. Yes,
as
Lordship.
per the instructions.
Yes, Lordship.
You see at 3.1.1, past performance not complied with.
Lordship, we have complied, Lordship, which I have given in page number 32, Lordship.
Who's to test that? The court's not going to sit over that to see whether if their evaluation says that. See, during technical evaluations, observe that so and so failed to submit complied certain mandatory documents information, specially required under the bid conditions.
Past performance,
I think
Lordship.
you'll have to file separate petitions. You can't sustain one against three separate bids.
Lordship, this similar, Lordship, the
If
same.
you want to go there, then your case will just be stuck in the mud. Yes.
Lordship, but however, Lordship.
But Mr. P. Ghosh, the consular petitioner, you should notice Dr. N. Mozika is present with MS GSEI with MS Jala. All the respondents. Yes, all the respondents, no further notice required. The grievance petitioner is with. Where the rejection?
Lordship, it's in page number. It shows online. It shows that we are disqualified, Lordship.
Yeah, where's that?
I've given in page number 34.
Yeah, then you should
35,
take
30,
this code first to that.
35, 36, and 37, Lordship.
Grievance petitioner.
5 number is perfect stamping.
That is bid for supply of kitchen utensils was rejected and without any reasons being ascribed. Mr. P. Ghosh submits that all the requirements as stipulated in the tender documents have been complied with, and as such the disqualification of the petitioner is without any basis. He therefore prays for some interim protection at this stage. Yes, Dr. M. Mozikal, SGI, who is present, has produced a communication dated. What is this? A communication or is it what can
It's
be
communication,
done?
29th
Communication dated 25th, 29th, 2026, and has referred and has at the outset, Dr. M. Mozika brings also has raised a preliminary objection with regard to the sustainability of the writ petition on account of the fact that the writ petitioner by the single petition has put a challenge to 3 separate bids, which are three separate bids which are different causes of action. He therefore submitted on the ground alone. On the ground alone, the writ petition deserves no consideration. The learned senior counsel has also produced a set of instructions dated 29th May 2026, showing wherein the reasons for rejection of the bids of the petitioner have been indicated. He therefore further submits that as per it submits that the writ petition is also afforded an opportunity to rectify and clarify deficiencies within a 48-hour period, 48 hour window, which however is not availed of by the petitioner, and as such no relief. And as such, he is not entitled to any relief at this stage. Here will counsel the parties. Let an affidavit. What will you do? We will treat this only as again one bid.
Yes, Lordship.
Will that be all right?
Similar cause of action.
On hearing. No. We're going to reject your writ petition otherwise. We're not going to entertain it. If 3 separate bids, you can't have a blanket petition.
Reasons for rejection also different, madam.
Yes.
Lordship, they have not provided anything in online.
Now you've got in your hand. Yes,
now their Lordship, they have provided.
Having heard the counsel of the parties, it is noted, firstly, on the primary objection raised by the Senate Council, it is noted that it is noted that in the document of the writ petition itself at page 13, 4 separate bids have been mentioned on which the writ petition had tendered, and on which 3 have been tendered for with the petitioner. Stop. Prima facie, it appears that the bids being separate and the reason for rejection being also different, a single writ petitioner will be able to sustain the grievances with petitioner. Accordingly, we'll dismiss it if we can file afresh. Accordingly, the petitioner is dismissed, however, liberty of petition to file afresh. Yes.
Item number 3.
If so advised. Yes.
3.
Yes, Mr. Paske.
May I please, Your Lordship? Your Lordship, my challenge is to the selection process of Gram Sevak, Your Lordship, conducted by the District Selection Committee, South Garois, Bagmara, on ground of arbitrariness, biasness, and nepotistic selection, Your Lordship. When I say nepotistic, Your Lordship, because the member, the vice chairman's son was appointed here.
Of the DSC?
Yes. And Your Lordship, and that
where do you find that in the petition?
Where have you said so?
Where have you said that? And how do you substantiate that?
Your Lordship, may I please, Your
He is
Lordship?
the son of the vice chairman.
Yes, Your Lordship.
Your Lordship may issue notice, my lord, because appointment has already taken place. So then, if
already taken place,
already happened.
Where's the appointment order?
Your Lordship,
See,
the result
I have got the
is
instruction.
at Annexure 9, page 66, Your Lordship. My Lordship has it.
How many posts were there?
9.
There were 9 posts, Your Lordship. 1 unreserved and 9 reserved posts, Your Lordship. Your Lordship, I just point.
No, 9 posts. 1 unreserved and the rest OST, yes.
Yes, Your Lordship.
Yes.
Number 9 is the son of the vice chairman of the DSC.
Charles Anang Marak.
Yes, Your Lordship. Son of Sri Hillman. So Hillman is the vice chairman, Your Lordship.
Where is the member?
The one here, Your Lordship.
Why have you not filed it with the writ petition?
Your Lordship, I got it late.
Have copy. Because, my lord, I don't have instruction on that aspect.
Your Lordship, the vice chairman, Your Lordship.
And my friend has to put it on the affidavit, my lord.
I'll put it, Your Lordship. Your Lordship, the petitioner here, one of the candidates, he had applied for the post of Gram Sevak, Your Lordship, and under the reserve category as per the advertisement, Your Lordship. He appeared in the entire selection process, Your Lordship, and performed exceptionally well, and he secured the highest marks, Your Lordship.
How do you know that?
Your Lordship, at Annexure 11, Your Lordship, page 68, Your Lordship.
Your name is?
I am at serial number 10, Your Lordship.
Yes.
I secured 238 marks, Your Lordship, under the reserve category, in written marks, Your Lordship. And Your Lordship, I was given the lowest marks, Your Lordship, in the personal interview, Your Lordship. Despite my performing very well as to the questions that were asked with me, I replied it with competence and confidence, Your Lordship.
You got only 15 in a personal interview.
Yes, Your Lordship.
And this where's that other person?
The other person got the highest, Your Lordship, 42, Your Lordship, out of 50, Your Lordship.
Deep Jyoti Lamok got 43.
43, number 9, Your Lordship.
Number 9 got 42.
Yes, Your Lordship. Even, Your Lordship, number 4 is the kith and kins of the DSC members, Your Lordship. There are 2-3 candidates who are the kith and kins of the DSC members, Your Lordship. Your Lordship, such selection of a close relative or kith and kins of members of the selection create.
My lord, instruction is this, my lord. Advertisement was issued on 13th August 2024, my lord. Physical efficiency test was conducted on 11th and 12th November. 1,293 candidates passed. Results were declared on 14 December 2024. Shortlisted candidate appeared for written examination, which was held on 2nd August 2025, and result was declared on 10 December 2025. Personal interview for qualified candidate was held on 8 January for 29th qualified candidate, and final result was declared on 2nd April. Entire process was carried out district selection committee as per prescribed norms. As Sri Amir C.H. Marak, petitioner in the instant writ petition, also participated in physical and written test for qualified for personal interview.
So you just gave him just one below, huh? He was not even the waiting list also.
Because only 9 posts, 9, they select one they could have given, my lord. That
It's
is
a very cruel joke. It's a very cruel joke.
Oh yes, my lord.
Make him
That is that. And he is one of the meritorious candidates also. He has got highest marks also, my lord. I saw that instruction. I said to Mr. Paske that let the notice be issued because and then
but Mr. P. Paske, Learned Counsel for the petitioner issue notice. Learned AG with MS Arcoli is present on behalf of the respondents 1, 2, and 3. No further notice and respondents. Notice to the private respondents within 3 days. Stop. Mr. Paske is submitted by counsel petitioner that the challenge in the writ petition is to the selection list, whereby it is contended that one of the selected candidates is the son of the
vice
chairman of the district selection committee which conducts selection. It's further submitted that in spite of the fact that the writ petitioner secured the highest marks on written examinations, the district selection committee with the malified intent had awarded him the lowest marks in the personal interview, which resulted in his obtaining 10th position against 9 vacant posts. He therefore prays for appropriate orders and selections at this stage to stay the selection, to stay the further appointment of the selected candidates. Mr. General Advocate General with so has produced a communication under the hand of the member secretary to selection committee, wherein the
selected candidates have already joined, my lord.
Where is that?
That is last line of second paragraph, my lord. Second paragraph. However, the selected have already been appointed, already joined in their service after following due process, correct and
no. Where is it indicated that after the final results were declared on 2nd April 2026, the selected candidates have been duly appointed and have joined in their posts. He therefore submits at this stage no interim orders are called for. This court, on hearing the counsel of parties and also on examining the materials, has seen that the contention of the petitioner that he had secured 10th position and also the highest marks on the examination is correct. However, as is submitted that the appointment has since been accorded, no interim orders will be passed at this stage. Stop the government respondent directed to file the affidavit to bring on within,
because we'll have to go into the allegations also. What
within 3 weeks from today, petitioner also had to file affidavit with the list of the members of the section committee. Last paragraph needs to add the entire section process will be subject to the outcome of the writ petition. Yes. List of 3 weeks.
Respond number 15 allegations is directed against respond number 14. Lord.
I have made all the
So notices
candidates
have
the
to
parties. Your Lordship.
notices have to go to the private party. Yes, notices.
Daily list, item number 4.
Deeply obliged, Your Lordship.
Hello, this is the second appeal.
It's for admission.
Admission.
Well, is it fresh matter?
Fresh matter.
Oh. Where's what is the date of the order?
Impeach order is 8 April 2026, whereby the judgment and decree granted in my favor has been set aside and quashed, and also the execution proceedings also was quashed and set aside. So, my lord, I have filed a suit for rejectment in the year 2012. The defendant, the respondent number 1 and 2, has entered appearance and filed written statement and also cross-examined the plaintiff witnesses.
So what happened? So on appeal now your execution was proceeding.
Both the
You
judgment
in possession or you were recovering possession?
Yes, my lord.
So what happened?
So, my lord, after the plaintiff evidence was closed, in the year 2019, the respondent, both the respondent has appeared before the court and submitted that they are not willing to proceed with the case, Your Honor. My lord, the order is at Annexure 7, page 77.
This is before.
So the name of defendant number 1 and 2 stands straight out by the.
No, why is it shown to in the appeal section? 2 courts are shown. Why? On the top says court of DS Marpanyang, and in the same page in the court of SV Lachma. How is this possible?
Well, Lord, actually the name of the presiding officer was SB Lightma at that point of time. So it seems we have applied copy in the year 2025.
Now how can they show an order is being recorded? How the way it was passed?
The signature of the presiding officer is there.
No. See. No, why is it this way? The order as it stands in the record is how it will stand. In whose court it is. It can't be 2 presiding officers.
Yes.
Be shown.
In fact, this order was passed by the then presiding officer.
Oh, fine.
So we have applied through the present
The
presiding
format should
officer.
be correct.
Yes.
Yes.
So in 2019, the names of defendant number 1
So
and
1 and notice 603. What happened after that?
number 3 did not appear after issuing notice. Notice was served through substitute service also. So the suit went ex parte against defendant number 4 and number 3. Then defendant number 4 also filed a petition, refused to contest the case, and his name also was struck out. So, my lord,
the decree was passed when?
23 September 2024.
20 September 24. Since 24. Then what happened after
On the
that?
same year, we have filed execution proceedings. So, my lord, the defendant number 1 and 2, respondent number 1 and 2 here, has filed an appeal challenging both the decree.
Who's respondent 1 and 2? They were the defendants then?
Defendants.
They refused
Those
to
who
contest,
won
they
the,
refused
yes.
to contest the suit.
Yes.
And after this decree ex parte, they went an appeal.
Yes, ma'am.
Then what happened?
Their claim is that once they strike out the name from the suit, they are no longer parties in the suit. So that is their claim, yeah. My lord, you can see the defendant has contested the suit based on the written statement and cross-examination of the plaintiff witnesses. So after the cross-examination of the plaintiff witnesses, they wanted to withdraw themselves due to showing that they are unwilling to contest the suit.
Now who's this?
My lord, in fact, the learned presiding officer, while passing the judgment and decree, has taken the cross-examination of the defendant number 1 and 2, has taken into consideration, my lord. The defense was not struck out by the trial court.
Okay. So without representation, the suit, your appeal was, the appeal was allowed. So who filed the appeal?
The defendant number 1 and 2. Defendant number 1 and 2.
2 and you said the 2 and 3, they didn't want to contest the suit.
3 and 4. 3 has been proceed ex parte. 4 has is not willing. 1 and 2 also is not willing to contest the suit.
Then who filed the appeal?
Defendant number 1 and 2.
Oh, then they said
After they got the notice for eviction from the
execution
proceedings, my lord. So they went in the same court for stay of the execution. However, it was rejected, and they went on appeal.
So were the names struck off from the suit or not?
As per this order 78, my lord, the name was struck off. In fact,
where is that? Then if the finding is there that the name
my lord.
Yes, I heard Mr. Archival issued this returnable in 2 weeks. Steps to be taken within 3 days. Yes. List thereafter for admission hearing.
Obliged.
Item number 5. 5.
My lord, we have filed our affidavit regarding this matter, my lord. Council has filed the affidavit.
What affidavit?
Clarifying that my lord's order, earlier occasion, lordship passed an order. That order is very clear. According to us, my council, they are supposed to approach the headman for fresh NOC. And thereafter they can approach the council. And the council will process in accordance with law.
Lordship, may I have that
I've given copy to my colleague also.
affidavit, internal page 4, my lord. Just above.
Their affidavit.
Their affidavit.
Yes.
Internal page 4, the paragraph on top, lordship.
Yes.
Accordingly, the answering respondent appointed the special officer and by letter dated such and such, the said officer requested the applicant to obtain fresh NOC from the concerned traditional head as the Sardar of Majai to enable the council to process the application for granting fresh trading license in accordance with law. However, the applicant did not furnish the NOC till date. Lordship, the impasse is that the Sardar of Majai is not in a position because of orders that passed by district council to issue any NOC, lordship.
Not to issue any anything.
Not to issue any NOC. Now, when we go to the CM, CM says, I have no role to play.
Now, CM is powerless also.
Lordship, yes. Now, when we go to the Sardar and the Dorbar Shnong, he says that since you got the original NOC from the CM, better you get it from the CM. And there is an affidavit filed by the...
So what special officer was he doing?
But
no, special officer
was
as he process all the applications.
He is supposed to process, my lord.
Then?
Once he submit the application along with the NOC, he has to process it. Then the Lordship
So, but
directly.
if they can't get an OC, they go there also, they say no,
My Lord-
they have to know then.
My Lord has colleague has pointed out, may I just place this order issued by District Council. Some clarification, some confusion was there, my Lord. Therefore, it is clarified. Now the
No, but does the Sardar of
Sardar
Majai
can-
have the
he can
competency
issue
to
NOC.
issue NOCs?
Yeah, he can issue NOC. That clarification, my Lord. Lordship Guide take the pain to peruse that order.
You have put in the affidavit one.
My Lord, so there was communication unable to annex, but this is the instruction, my Lord. Lordship Guide take
Very,
cognizance
this
of
is
it.
very material. It has to be annexed.
This
is very
Put
recent.
it in affidavit, then we can take it on record.
My Lord, that
This
statement
is a code of record, Mr. Changre. So,
para 9, my Lord. In para 9 was in my affidavit, my Lord. We have stated there, in fact, seeking for Lordship allow us to record
no, when
that.
was this issued? 20th May.
Very
Madam.
recently, yes.
You file this by additional affidavit. File one copy now.
Please.
Yes, an affidavit has been filed on behalf of respondents 1 to
1 to 4.
1 to 4. So, wherein is indicated that the petitioners are to obtain the NOCs from the Sardar of Majai to enable the council to process the applications for granting fresh trading licenses. Stop. Today, Mr. H. Sanriso, Senior Counsel, has also produced a notification dated 20th May 2026 authorizing the Sardar Majai village to issue acknowledgement certificates or any other certificate required by the Majai. Stop. As the document is not on record, the respondent directed to place the same record by additional affidavits within 1 week.
Yes.
Just thereafter and so on. So.
Yes.
Finally, one.
Yes. Only developed.
Then we'll close the matter. Actually,
Yes.
Then it has to come record because
Yes.
there's a lot of confusion in this matter. As who the authority to grant NOC?
Yes.
Yes.
48.
Please, Lordship. So this is the matter where, my Lord, we have challenged the order
This
of
is
the
for hearing.
This is for admission hearing.
Yes. Who's there for the respondent? Yes.
1 and 2 is the Lokayukta, Lordship, right? 11 to 13 are state respondents.
Yes.
Lordship, the brief of the case, my Lord, if Lordship would see page 23 at annexure 1 of the petition.
Page 23.
Page 23, Lordship, annexure 1. Lordship, this was the complaint. This was the complaint which was filed before the Lokayukta, registered as complaint case 7 of 24. And Lordship would see the array of parties. Respondent number 5, 6 and 7. They are, my Lord, VEC members.
Who's appearing for complainants? You are appearing. Yes.
Now the long and short of their complaint was, my Lord, that in the execution of the MG and REGS works there was some misappropriation. Now thereafter, Lordship, the present petitioners who were the respondents there had entered appearance and the matter was heard, my Lord. Thereafter, Lordship would see page 51, annexure 3.
Yes.
Lordship, if I may read, Mr. So and so, learned counsel for the complainants present, so and so learned counsel for the respondents 2, 3 and 4 who are state authorities present, so and so learned counsel for respondents 5, 6 and 7 present, respondent number 1 absent without steps, heard parties. Prima facie case exists against the respondents. The Director General of Police shall depute an officer not below the rank of DSP to investigate the case under section 20(5) of the Lokayukta Act and to submit the report on or before the 15th January 2026. Now, my Lord, we are aggrieved by this order on the ground that on on the ground that, my lord, that the VEC members do not fall under the jurisdiction of the Lokayukta under section 14 of the Act. And the second ground is, my lord, that that I have placed by way of an additional affidavit that there was already an order, a judicial order which has not been, my lord, interfered with, passed by the Lokayukta itself in 2022 in a similar case, my lord, where it was the complaint was dismissed with a finding that these VEC members are not amenable to the jurisdiction of the Lokayukta, lordship. Now these orders were placed before the learned chairman, but unfortunately nothing was even recorded, and only what was recorded is prima facie case exists.
You not come in the meaning of section 14?
Lordship, section 14 essentially, my lord, talks about bodies. There is one provision which talks about any bodies, authorities or bodies by whatever name called, but those have to be, my lord, receiving salary. They should be gainfully employed, receiving salary.
So under Prevention Corruption Act also they don't come with the meaning.
Lordship, there is a
PC Act.
speaking order of which I have put in my additional affidavit, my lord. If Lordship would see that order in my additional affidavit, page 5. It's passed by the same authority, Lordship.
2526.
Lordship, yes, additional affidavit filed on 2526. Page 5 of that. Lordship, this is an order of 19/5/22, passed in complaint case 3 of 21, my lord. If I may just read, this complaint petitions under section 20 of the Lokayukta Act filed and registered on so and so, SP Economics Wing. I'll just skip this first paragraph, my lord. Hearing under section 20(3) of the Meghalaya Lokayuktas were heard today. She so and so learned counsel for the respondent submitted. The respondent number 1 is the chairman of VEC, number 2 is the secretary of the VAC, and the respondent 3 is the ex-secretary of the VAC, so and so village. The chairman and the secretary of the VAC are not within the jurisdiction of this forum as laid down under section 14 of the Meghalaya Lokayukta Act and are not public servants read with clause 3 of section 2 of the PC Act 1988. She so and so plays for 1 week time to submit a submission. Learned counsel for the respondent object to the prayer. I'll just skip this one. The finding: the chairman and the secretary of the VC are elected members of the job card holders to run the affairs of the village employment council for execution of the Mahatma Gandhi National Rural Employment Guaranteed Scheme in the concerned village without payment or annual income. Their names do not find either place either in section 14 of the Lokayukta Act or under clause C. So this was placed before the Malod.
Can they take a differing stand, not a stand in legal position of the same authority?
My lord, I'll attempt to establish this earlier order was placed, was passed, my lord, under a certain misconception. I'll establish that. But my lord, before that, I have three main objections against this.
How long you will take?
10 minutes.
Otherwise, you already will hear it in totality.
My lord, in fact, it's for admission hearing. It can be disposed today itself, in my humble opinion.
Yes.
My lord, three.
What about the complainants? Yes.
My lord, three broad objections. First being, my lord, the chronology is important. This complaint, my lord, was filed in September 2024. And strictly following the procedure prescribed under Section 20 of the Lokayukta Act, my lord, first, a preliminary inquiry was ordered by the Lokayukta. Preliminary inquiry report, my lord, was submitted.
matter proceeded, my lord. Finally, on 15/7/2025, this impugned order was passed, my lord. So almost a year had passed.
Yes.
And that being the case, my lord, my first submission would be that they have submitted themselves to the jurisdiction of the Lokayukta, my lord. My friend states that this aspect of the previous order of 2022, etc., was raised. There is nothing on record, my lord, and we have to go by the records, my lord. From the records, it is evident that the first instance that this issue has been raised is before this honorable court by way of this writ petition.
Yes.
So I would my first point to sum it up would be that this writ petition, my lord, is premature.
So we'll do one thing. We'll remand it back to hear this point.
Karnataka High Court, my lord, has done exactly that in an exactly same manner.
Yes.
With the greatest respect, my lord, to contend, my lord, that this issue was not raised and I have only raised it in the writ petition is not correct, my lord. I have, in fact, in my writ petition, I have specifically averred that despite placing
there
the
was
order,
no finding on your contention.
Lordship,
That's why.
Lordship, if I can place this small judgment from Karnataka, Kerala,
and the other part is that I had come after 1 year of the filing of the
Material,
complaint.
if in law, if it's not maintainable,
Because I only get notice after the report is filed, my lord.
my lord, a similar issue in a Lokayukta matter from Kerala is just one paragraph. I'll read, my lord, quickly. This writ petition is filed challenging Exhibit P7 order passed by the Kerala Upper Lokayukta, whereby a secretary of the bank is restrained from functioning as the secretary. It appears that this order has been passed at the admission stage itself. The petitioner, who is aggrieved by the order passed by the Kerala Upper Lokayukta, has approached this court challenging.
Yes, sir. Anything to say, MS?
Only the last part, my lord, that the interim order will continue till the matter is decided by the local.
It's fine that we'll look after. Only thing is, you see, the only thing is that it is, if he had raised it and no findings recorded, then record a finding.
My lord.
Yes.
State council was there.
So now there'll be directions. Now he'll hear it.
And my lord, with respect, my lord, the interim order passed earlier cannot continue, otherwise hands of the Lokayukta will be tied. Interim order was not to proceed. So if that interim
investigation,
we will direct that he decides on a point of jurisdiction. That's all.
Yes.
And if he comes to finding after that, then he goes ahead.
Very well.
Or he drops the proceedings.
Very well.
And if he's aggrieved, he'll come back.
Very well.
In the meantime, this DSP inquiry should not be, investigation should not be conducted. Well, on one hand, they will conduct inquiry and then...
That is
the
fair.
petitioners
That is
who are
fair.
stated to be VEC functionaries of Nongladao village, Ribwai district, Meghalaya, are before this court sealing an order dated 15/7/2025, whereby the respondent number 1 has assumed jurisdiction with regard to the complaints lodged against the petitioners by respondent number 3 to 10. Stop. It has been submitted by the learned counsel for the petitioner Ms. S. Deb that the directions for investigation and for further proceedings by respondent number 1 are without its jurisdiction, and in fact is in the face of earlier orders passed by the said office itself with regard to matters pertaining to investigations or complaints against VEC functionaries. So in this context, learned counsel has drawn attention to this court to an order dated, where's that,
19/5/22.
19/5/2022, passed in a complaint case number 3/2021, wherein the earlier incumbent, or respondent number 1, had come to a finding that the chairman and secretary of VEC are not amenable to are not find place in section 14 of the Meghalaya Lokayukta Act 2014 or under clause C of section 2 of the Prevention Corruption Act 1988. He therefore submits that the entire premise for entertaining the complaints being not supported, being incorrect, that the petition be allowed and the proceedings before the respondent number 1 be quashed. Ms. S. Jindal, appearing for the
1 and
2, has however submitted that the writ petitioners had submitted themselves, the writ petitioner has submitted himself to the jurisdiction of the respondent number 1, inasmuch as it was a lapse of 1 year that it came to this court.
Yes, ma'am.
It's a lapse of 1 year after complaints had been lodged that approached this court. So he further submits that the earlier order passed by the early order dated 19/5/2022 referred to by the writ petitioners was
passed by the earlier chairperson under a misconception.
Was passed by earlier chairperson under misconception as to the applicability of the law, of relevant law. So he therefore prays that he therefore submits that he also submits that writ petition is premature at this stage, and that the proceedings and the preliminary investigation has also been concluded.
Is already concluded.
Is already concluded. Nick Barav, then MS VF Karunlang, appearing for respondents number
3 to 10.
3 to 10 has endorsed submissions made by learned counsel for 1 and 2 and has not tendered any further submissions. So, Mr. N. Sankon, your for respondent number?
11 to 13.
Mr. N. Sankon, on behalf of the state respondent 13, however, has supported the contention raised by the writ petitioners, submitted that this fact had been brought to notice of the respondent number 1, who, however, did not render any finding in this regard. So, next paragraph. On hearing the counsel of the parties, was examination of the impugn order as well as the order dated 19/5/2022, passing complaint case number 3 of 2021. What appears to this court in the first instance is the question of jurisdiction, which is yet to be decided by the respondent number 1 itself. Accordingly, in its view of the matter, and to shorten the process and to according not to linger on the matter any further, in the considered view of this court, justice would be served at the stage if the matter is remanded back to respondent number 1 to firstly decide on the point of jurisdiction before proceeding any further with the matter. Accordingly, as ordered above, the matter is disposed of. Should we give a time limit?
For deciding this question, my lord. That means as expedited.
The matter is disposed of with directions that the respondent number 1 shall hear the matter afresh on the point of jurisdiction. And until such orders are rendered, no further proceeding to regard investigation shall be undertaken by the respondent number 1. Yes.
Obliged.
49.
The second matter, only the complaint case number would be different.
In view of the order passed in notice which will cover the instant case, this instance represent disposed of on same. Or will change the number only.
Only the complaint case number is different.
Same complaint.
More or less, my lord. A bunch of them are similar. Only the respondent number and the case number. Obliged.
50.
This is a contempt application, my lord. We filed an affidavit indicating compliance. Now, Mr. Jha is not happy on 2 counts, my lord. One, first, my lord, there is a belated compliance, my lord. The direction was for 3 months, and there's a delay in compliance. And second objection is that the affidavit is not filed by the.
So what happened? How does order dated 7/5?
But nothing has happened after that, my lord.
Then
The second aspect is, my lord, the objection taken is that the affidavit.
file additional affidavit.
We filed an affidavit on 7/5/26, my lord. Now this affidavit filed by OIC Pension Cell, my lord, Record Branch. Now he is a respondent in the writ petition, my lord. In the contempt application, only the Home Secretary and Director General are
objected that, my lord, even filing a reply in the entire affidavit, my lord, there is nothing as such ki what is the process, even assuming, my lord, that percentage is that much, my lord. The respondent here in that they say that in the affidavit, my lord, ki it is not attributable to service. My lord, my lord is well aware that the scope of the contempt proceeding, my lord, cannot reopen the writ petition which is already.
You will file appeal.
No, my lord.
He retired 48 years
48 years, that's the one. The directions are only to reassess.
Out to some via media where it's just, it's you give him something. His level of percentage disability is 13.114. You don't accept that.
My lord, that this is the second time they have called. Earlier to that, my lord, I have today I have filed a reply to that affidavit, my lord.
Where's that reply?
My lord, I have served a copy. It is with the registry, my lord.
Not served.
After 1 week, yes.
Copy has been served.
Just after 1 week, Mr. Arja submitted to join has been filed with the affidavit by the respondent. Just after 1 week for further orders. Yes.
My lord.
51.
Okay.
This is a contempt.
Where's the affidavit?
I prefer one more time.
You will file?
Your Lordship. Not yet, Your Lordship.
It's a contempt matter. If you don't file affidavit, then
Yes, I
you
apologize,
have to
Your
go to
Lordship.
jail. You know that?
Yes, Your Lordship.
You know that or not?
Yes, Your Lordship.
When will you file it?
I prefer
In a
2
course of
weeks
a day?
time. No, Your Lordship.
You give them 1 week's further time. You want further time, you file it, otherwise you'll be in trouble. Yes.
52.
My lord, here I have received the affidavit of the private respondent today itself. Here, after going through the affidavit, my lord, that my lord will kindly see page 13 of the affidavit filed by the respondent number 4.
4.
Respondent number 4.
There's no 4 here, it's only affidavit by 3, 5, 6 and...
They have filed it today, lordship. I think it is not, it has,
We have filed it, Your Lordship.
it has not raised, lordship.
What does it say?
My lord, here they have enclosed one documents, that is the resolution. The resolution which says that by this resolution they have withheld my seniority, lordship.
Okay, then MS Anlamari submits that on behalf of number 4. You with Mr. SD, correct?
Yes, yes, Your Lordship.
After it's been filed to DSL, just after 1 week for the orders.
Then let it be 2 weeks. In the meantime, I'll take instruction, lordship.
Yes, just after 2 weeks. To allow the to obtain instructions. Yes.
Must.
Yes.
My lord, I have a letter that says that the service of the petitioner is regularized. I have a letter, my lord.
You're aware of this?
I just got this letter.
Sama?
No, Your Lordship.
No.
No, Your Lordship. My lord, the cabinet has approved his regularization. The letter is 14 May 2026. The next page, my lord.
Your Lordship, if I may pray, Your Lordship.
Where's the name of the petitioner?
The name is at the last page, my lord. He's at serial number 3.
Gretel Sun Movement. We'll close it.
Lordship, if I may pray, Lordship, let them bring on record, Your Lordship.
Not necessary. This one will work better for you.
Lordship.
I've given them a copy, my lord. They can take it to the department.
Yes, sir. MSOI Bank today has produced a communication dated 15 May 2026 addressed to the Chief Engineer PHE Meghalaya Shillong, wherein wherein the petitioner's name finds place among the list of ad hoc employees
Yes, my lord.
regularized by the Cabinet on 5th May 2026. And this is the matter. Nothing remains for consideration. The petition is closed. Our liberty to the petitioner to pursue further, to seek further remedy if a fresh cause of action arises.
Lordship, this is for regularization and for the pension also, Lordship.
Further, regularize you? Yes.
He'll get his pension, my lord.
But this is a joint petition, my lord, with 23 petitioners. On the last occasion, the union had objected to the joint petition on the ground that they are not similarly situated. So I've obtained instructions, my lord. My lord, seek liberty to withdraw this petition, and I'll segregate and file a fresh one.
Yes, Mr. Film Nombri and Council petitioner submit the instruction, please allowed to withdraw this petition and to file a fresh. Yes. Praise allowed.
55.
My lord, in this matter, my lord, we'll be filing our reply to the application during the course of the day, my lord.
Yes. Yes, the council for the response, Mr. Please submit the
Reply to the
objection.
application. Objection.
Objection to the miscase.
Miscase.
Miscase, correct?
Miscase.
Amendment to the course title.
Oh, you file objection to the affidavit.
Yes.
What do you file?
Course title. Amendment of course title.
You file to the application. The miscase, that means. Where's your
Miscase, my lord.
The miscase. I miscase. 132. Miscase 132. Mr. Vidam submits that. Objection will be to the Mrs. application to file a court.
Miscase 132.
Just after 1 week, together with main cases.
Deeply attached.
56.
Yes.
I know.
This is a transfer petition, my lord.
No, please, Your Lordship. We will file the objection, Lordship.
You filed?
We will file.
Today?
No, Lordship. After 2 weeks, Lordship.
Yes, also, please funds allowed 2 weeks time for objections. Just thereafter.
57.
Main matter is listed tomorrow before division bench in this country.
Yes, this was.
My lords, the state's supposed to file their objections.
58.
You're filing today, affidavit. You're filing today. Filing today.
What's the day? Dr. Nvozika Leonard, DHS submits that the affidavit on behalf of respondents will be filed the course of the day. Just after 2 weeks for rejoinder of any.
59.
Yeah, I'm praying for some time. 2 weeks time.
Further 2 weeks time as prayed, allowed for affidavit. This together with 54. Yes?
No, but so this is separate matters.
I thought we just together. It's up to
60.
Respondents are yet to file the affidavit, Your Lordship.
Why you not file affidavit? How many times you've taken?
Now to seek clarification on this notification.
GHDC?
GHDC, Your Lordship.
Yes.
To seek clarification on this notification, Your Lordship, from the District Council's Affairs Department.
Can't hear you. Speak up slowly. Yes.
We'll seek instructions from the the notification, this DA 682571.
What is that notification? What does it say?
Yes, about that for payment of salary, Your Lordship, from the state government.
What's the matter about something?
Payment of service benefits, Your Lordship.
To whom?
To the petitioner, Your Lordship.
Working as what?
He was working as a HA, Your Lordship. He retired as a HA.
In a school?
And in the district council, Your Lordship.
Okay. What clarification you want to say? You're saying where's that petition? Where's the notification? Where is it?
It's It's not here, Your Lordship. That's why we are seeking clarification on this notification.
No, you're seeing that which notification? Is it part of the records now or no?
It's not annexed in my petition.
Not yet.
Okay. Then you ask for time, yes. You filed.
Your Lordship, I won't be filing any affidavit, Your Lordship.
You are?
This state, Your Lordship. Respondent number 1, state.
Okay, yes. MS submits a note report coming from number 1. Order number 2, Mr. J. Sushang.
Yes, Your Lordship.
Please further for a 2 weeks time for affidavit. We are going to seek clarification for affidavit. Please allow this.
61.
Yes, Dr.
It's
Mazika.
for affidavit only. I'm bringing some time. The first date today.
All the way you come. Yes. As paid for a 2 weeks time. 3 weeks time.
3 weeks.
Allowed for affidavit.
62.
Close I'm bringing some time. First date.
3 weeks.
63.
Lordship, we have already taken step for respondent number 4 to 6.
Who will bring 5 and 6?
File wakala nama, Your Lordship, for
5 and 6?
number 4, 5 and 6.
So 4, 5 and 6.
Yes, Your Lordship.
So you're paying by yourself?
Yes, Your Lordship.
And for respondent 1 to 3, Your Lordship.
Correct, from the same chamber. Yes. Mr. J. Suchang. And that appearance today on behalf of respondents 4, 5 and 6. Such notice is complete all the respondents. He prays stop. And then MS and Lamare for 1 and 2.
To file affidavit, Your Lordship.
And so and so. For pay for 2 weeks time for affidavit. Yes.
Right. Obliged.
64.
Lordship, here the petitioner is already receiving the pensioner benefit. I pray that matter may be disposed of.
It can be disposed of, Your Lordship.
Yes. So submits that.
They're receiving the pension, the gratuity, as well as the encashment for earned leave.
It for already been addressed. She prays that matter may be. We will have to withdraw the matter. She is not objected to by another AEG. Next on the matter. The submission party, the matter stands closed and is closed up on withdrawal.
Obliged.
65.
My lord, this is the case where we were assailing the order passed by the executive magistrate in exercise of power under section 164 and 123 of the BNSS, 126 of the BNSS, my lord. The issue was, my lord, while passing the order, what was the power of the executive magistrate under 126? His position, his power was to inquire whether who was in actual possession when the proceeding began. And secondly, my lord, 126, his order, his power is to ensure that there is no law and order issue, that to ensure the peace and tranquility exists. These are the only two orders. What happened? A construction, a building which has been under my possession since 2012 by way of a registered deed, and there's a building permission, and I have been constructing this building, my lord. When it's almost half done, my lord, somebody files an FIR. That FIR gets converted into a proceeding under section 164 and 126. The magistrate says that I have inquired and I'm satisfied that the possession, the possession of the building of the land is with the respondent herein. Therefore, I give the possession to the respondent, my lord, by dispossessing me, my lord, who was under construction, my lord. Now, by doing so, my lord, this is not only it's not a preventive order, my lord. This is something order which has been passed without jurisdiction, my lord. Therefore, I am aggrieved by this order. Now, my lord, what they're saying is, what the respondent is saying is, they're saying before this, my lord, they're saying this order, this
writ petition itself will become infructuous. Why? Because I got an injunction from the civil court. Fine. I can go and fight the injunction. I can go for variation, recall of the injunction.
But you have not handed over possession, have you?
I'm sorry?
You're still in possession.
No, I was in the possession. I was dispossessed and handed over the possession to respondent. Now the respondent files an eviction suit against me. And the learned court below files an injunction order against me. But I am in the possession. So this, by their own act, there's so much of complications. But my primary objective here is, my lord, this order passed by the impugned order, which has been passed by the executive magistrate, my lord. That's on 31st of March 2026, my lord. This is an order which has been passed without jurisdiction. So this order must go, my lord, and we'll ensure that there is no law and order in this. We will contest the civil suit that they have already filed an eviction suit, because I also have a registered deed over the same plot of land, my lord. My registered deed is even registered prior to their deed of declaration, my lord. So now there are two deeds over the same plot of land which are both registered. Mine is registered even prior to theirs, my lord. And I also got a building permission, my lord, on the strength of this deed of the registered deed, my lord. So, my lord,
where the order of title suit?
My lord, is 31st of March 26, page 28. That's the order.
No, possession. First party is Robert Moplang. Yeah, Robert Moplang.
Yes, sir.
Yes. Page 20. Register deed. Our register deed.
Sure. Sure.
Page 15 onwards. So judge, take out a judgment.
हम लोग का होना
You see this order? No.
My lord, I'm just saying now because we are yet to receive the notice, my lord. And
you contested there.
Yes, my lord. I will contest, but this order, my lord, this order,
This order says until the competent civil court takes it up. So we'll not go into that. You can close it. That
My lord, this.
But the finding on possession is not to be given. That's all.
Yes, yes.
Yes,
fine.
Lordship, and-
Another strange thing is that if you file a suit for eviction, then how can injunction be granted in your favor?
Yes.
Lordship, even the prayer is recovery of possession because I was already in the possession of that, Lordship. Lordship,
He says that.
Lordship, paragraph 4 is very clear of the order, Lordship.
Just says that don't raise construction, selling, transferring, alienating.
Lordship,
So your
it is-
possession is not. The civil code has.
We had not been decided, yes, Lordship.
No, they have not restrained you from being possession of the property.
No.
You look at the order.
Just
look at page 4. Okay.
Yes.
Para 10.
Yes.
According to this court is inclined to grant interim ex parte injunction, not dispense with other agent raising any further construction suit land, selling, transferring, alienating, encumbering, or creating any third party interest. That's all.
No, that is all right, my lord. But what I am
the injunction order, it's only limited to that.
Limited to that, my lord. What we're saying is,
yes, the writ petitioner.
my lord, kindly take
With an
consideration.
Order dated.
Yes.
Order dated. Order dated. Where the order?
25/5.
Order dated page.
The impugn order, my lord.
Yes.
That is 31st of March 2026, page 28, my lord.
Yes, Pamna?
Page 28.
Being agreed with.
Yes.
Order dated 31/3/2026, passed in CT case number 42/2025 under section 126/164 BNSS for this court. Assailing the same. Stop. The brain ground put up by the petitioner is that the executive magistrate has committed a grave illegality in passing in declaring possession in favor of the opposite party respondent, when in fact by law the same is not called for. Stop. What is your submission, P.I. Ubin?
My lord, because yes, I was submitting the power under section 164 and 126, my lord, and in support of that, my lord, I am citing two citations, my lord. Let's go for this. Yeah.
Mr. P. Ubin, Council Petitioner submitted that the power as provided in section 164
where I'm saying that the role of the magistrate
164
yes
and 126 of BNS is only for adoption of procedure where dispute concerning land or water is likely to cause a breach of peace.
Breach of peace, yes.
So, it's further submitted that under 127, it only speaks about obtaining security for good behavior.
Yes.
From persons disseminating certain matters. So, under the set provisions, it is contended there is no scope or whatsoever to declare possession
yes.
in favor of any party.
Yes, and in support of that, two citations.
Why you want to give citations?
My lord, this is a very good citation.
It's very good because you took
164.
you took the effort to research it. Okay, fine. Let's
my lord.
Yes. In support of its
Ashok Kumar. First is Ashok Kumar.
The Learned Council has placed reliance upon
paragraph
provisions,
6,
namely Ashok, the Supreme Court, namely Ashok Kumar versus State of Uttarakhand.
Yes, my lord.
2013 3 SEC.
Paragraph 6.
And
also
1960 EIR 1968. And the case of R.H. Bhutani.
Yes, my lord. Paragraph
Bhutani
8.
versus
Paragraph 8.
Miss Mani J. Desai and others. EIR 1968 SC 1444. It therefore submits that the action of the executive magistrate being out in jurisdiction, the impugn order is liable to be set aside and quashed. Where's which paragraph?
Paragraph 8, 8, 9 and 10. The Ashok Kumar is paragraph 6, my lord.
Yes.
Ashok Kumar, paragraph 6.
Yes. Next. MS SK Norum appearing for the sole respondent.
No, Lordship, for respondent number 5.
Respondent 5. Respondent 5. Who is the complainant?
Yes, Lordship.
So the first party in the 164, in the 126/164 proceedings, has submitted that the matter does not deserve any further consideration by this court in view of the fact that a title suit has since been instituted wherein orders operating. The legal counsel has produced for this court an order dated
6/5/2020.
6/5/2026 passed in Miss Case number 111 of 2026 in ejectment case number 6 of 2026 by the court, by subordinate this is the council court Nongpo. So the council has submitted that by this order the restraint on the petitioner is only against raising any further construction over the suit land and selling or transferring the same or creating any third party interest. So she lastly submits that as the matter is purely a civil dispute, the criminal proceedings have lost their force. She therefore prays that the repression be dismissed up. On hearing counsel of the parties, an examination of the provisions stop. From Fasai, it is seen that the learned executive magistrate has not appreciated the contents or the mandate or the stipulations, or have not appreciated stipulations of the provisions of and have not appreciated the stipulations contained therein, which deals only with the threat to breach of peace and for obtaining security of the persons concerned. So, in view of the matter, as the orders of jurisdiction, the impugn order set aside and quashed. However, next paragraph, before parting with the records as the matters before the civil courts, the petitioner can take appropriate action to contest the same.
Yes,
my lord. Much obliged.
Highly obliged.
As ordered above, matter stands closed and disposed of.
Much obliged.
Yes.
But this relates to disbursement of pensionary benefits by the MTC. Have instructions. We'll release it within 5 months, my lord.
Dispose 5 months, yes.
Obliged. Similar order for the next settlement.
5 months.
Well, next.
68.
5 months. Upon disposal, Sandasi. Yes.
Well, these are also tender matters.
Live ration. Live ration.
I have instructions on all these 3 matters. Give this one.
It'll take some time. We'll take a second half.
Today, I do not really think matter can be disposed of. I think we'll have to file affidavit. The instruction says that the price quoted by them is
not even settled.
Too low.
No, not yet. As far as 2 matters are concerned, price bid has been opened. Nothing has been settled. Third one is still at the stage of technical bids.
On the basis of instructions, can it be disposed of?
I don't know. It can be disposed of.
So also we'll have to see what the instructions are. On the last date, my lords will recall what the instructions were, that there was some fluctuation in the power supply, as a result of which they could not settle anything in the GEM website. So we don't know what that exactly means.
That is in regard to one case.
One case.
The remaining 2 cases, because these are they served from market
Figure
matter.
up at 215. Yes. Next order.
6970.
Connected matter.
68 to 70.
Supplementary cost this one. Item number 1.
Let it go before the other court then, Mr. Nauri.
No, not this one, my lord. This is somebody else, my lord. This is my lord Mansan Manik Same. He is the deputy Same, my lord.
It's the younger brother of the. It's the younger brother.
Arising out of the same.
My learned friend is not on caveat, my lord, in my case. I've served the district council, my lord. If your lordships kindly have my appointment, is at page 12, my lord. The translated copy is at page 13. I was appointed as Deputy CA, my lord, on 29th of April at page 13, 2024, which reads, my lord, appointment of, subject is appointment of Deputy CA in Hima Malayam.
Yes.
Upon the subject above, I have been instructed to inform you that the Executive Committee, KHDC, has accorded the decision of the Executive Darbar to appoint Shri Mansan Manik Same as the Deputy CA of Hima Malayam in accordance with the letter under reference. So it was upon the recommendation of the Executive Darbar, my lord, that I was appointed as the Deputy CA. My sanad is at page 15, my lord, page 14.
Yes.
Page 16 is, my lord, the order suspending the same, my lord. This is dated 22nd of May 2026. I am not challenging this order, my lord. The same will challenge the same, my lord. Now, if your lordships kindly have page 19, my lord.
Yes.
I'm challenging this order, my lord, and the notification at page 18, my lord. Appointment of the private respondent. If I may read the impugned order, my lord. This is also dated 22nd of May 2026. Whereas the competent authority has already placed the Chief of Malayam under suspension pending free and fair inquiry as per law. Whereas, however, the present Deputy Same is found to be the younger brother of the above suspended Same and therefore may not be appropriate to appoint the present Deputy Same to exercise all the powers and functions of the Same in the capacity of acting Same, which may likely affect the independent and fair inquiry, and also to avoid any perceived biasness as well as fair consultation process with the Executive Darbar headed by the above present Deputy Same is susceptible to biasness, delay, etc. The undersigned, under the instruction of the competent authority, under the peculiar facts and circumstances, hereby appoint Shri U. Alban Frederick Same as the acting Same of Malayam Sameship until further orders, and directed him to exercise all powers, all functions and powers of the Same under the Khasi Hills Autonomous District Council appointment of Same, Deputy Same, electors, Bashnong of Malayam Sameship 2007 and rules thereunder. Now kindly see the order has been passed by a single executive member, my lord. So, my lord, this order is, my lord, bad in law. In view of your lordships, may kindly have the act at page 20.
Yeah.
The first ground, my lord, there are three grounds of challenge. First ground, I'll take your lordships to competence, my lord. At section 25, your lordships will find at page 27. And the law is settled, my lord, on this point. If your lordships may kindly have section 25 at page 27.
Yes.
It says, my lord, the executive committee may by order and writing authorize two or more, my lord,
yes,
of its members to exercise on its behalf any power or powers conferred upon it by this act, and anything heard, any act done or order passed as such by such members of the executive committee shall be deemed to have been heard, done and passed by the executive committee. This is the first ground of, my lord, defect of this impugned order, my lord. And, my lord, I have also enclosed certain judgments, my lord, passed by your lordships and the other benches, my lord. If your lordships may kindly have page 31, my lord. Law settled, my lord. At least minimum 2. Page 31, my lord.
Yeah.
This is a judgment passed by your lordships.
Yes.
This is reported in 2025 SSC online, Meghalaya 378. If your lordships may kindly have para 3.
Yes.
And your lordship's finding is at para 5.
Yes.
Or para 6, my lord. A perusal of the above section 21 shows that the impugned order therefore is incompetent and it does not have the sanctity of law. So a single EM cannot pass an order under the Act.
That is
Yes, my lord. Now with respect to, now page 33 is another judgment, my lord, passed by your lordships. Now page 35 is, my lord, with respect to the Millennium Act, my lord. Page 35, my lord.
Yeah.
Here also, my lord, again the finding by the court, my lord, and also conceded by the district council at paragraph 4, my lord.
To say this council doesn't know what they're doing.
Yes, my lord.
Anyway.
So this is the first ground. This is the first ground of challenge, my lord. Second ground of challenge is, my lord, if your lordships may kindly have section 8 at page 23.
Yes.
Your lordships have page 23 and section 8, my lord. Section 8 reads, my lord, appointment of an acting aim. Subsection 1. If at any time the office of the same falls vacant as a result of death, resignation, retirement due to old age, removal or suspension, the executive committee may by order in writing appoint the deputy same, that is me, my lord, to act as an acting same who shall exercise all the powers and functions of the same. Now, my lord, the proviso is very important. Provided that when a situation is so warranted, the executive committee may, in consultation with the executive darbar, appoint any Khasi male adult belonging to the same Millennium clan who fulfills the qualification prescribed in section 3 above as the acting aim of Yes, my lord. So this is second ground, my lord, that the executive darbar was never consulted. Now, my lord, section 9, the third ground.
Yes.
The reasoning given in the impugned order saying that he is my younger brother, my lord, that is divorce section 9. Section 9 provides, my lord, election and confirmation of a deputy same or same khanna, my lord. It says when a vacancy occurs in the office of the deputy same, it is the duty of the same in accordance with the customary practices to nominate from amongst the adult brothers or nephew, my lord, of the same and shall introduce the new deputy same, my lord. So that reasoning is bad in view of section 9. Section 9 clearly provides it has to be a brother or a nephew. They cannot give a reason that the inquiry will not be will be biased in view of him being the brother. So this is the third ground, my lord. On these grounds, my lord, this impugned order has to be stayed, my lord, or rather may be stayed, my lord.
Only thing is that, see, normally if this impugned order is stayed,
yes,
there'll be a vacuum then.
Yes, my lord. So they have to consult the executive darbar.
There'll be a vacuum that he's under suspension. That order has not been. We'll await the outcome of the other matter because matter won't take up. They have objection to it.
No, this is prima facie bad, my lord.
Of course. I mean, even from the fact of
only one member, executive member.
See, Mr. Chaniso, I think you have to advise them.
My lord.
See, as a senior counsel also,
yes,
like regarding any executive action, because you cannot just what do you call it? It's a constitutional authority.
Exactly.
Constitutional authority has to act within the bounds of the constitution.
Right.
These acts are framed under 6th schedule, which is a part of the constitution.
Exactly. Oh, and we have a greater responsibility as an institution before this one.
Especially with regard to institutions.
Right.
A question of your own, executive considerations that you have to think through any decision.
Exactly.
There won't be a void, my lord, because if this order is set aside, my lord, if this order is set aside or stayed, my lord, the deputy's aim as per section 8 has to be appointed as the acting.
Then that order is issued by executive committee.
My lord, this order was issued by executive committee. May I just please original report also here.
This order has been issued by
my colleague challenge. May I just please.
Even then, Mr. Chaniso, because the act is very clear.
My lord, the executive committee has taken decision to appoint the acting chief.
No, yes, but then you see what the act provides.
My lord, therefore my lord, here the full executive committee has taken the decision to appoint the acting chief.
Right.
Not by here, my lord, the impugned page number 19 is only a communication, my lord. My lord, we just take the pen to see.
Yes. No, that was not really, what do you call it?
Because my colleague is challenging that is only one executive committee signed the paper, signed the impugned order, therefore it is illegal, man. My lord, kindly see 21st May and second page. If
regarding this,
my lord, second page number 2. Second, my lord, therefore the executive committee.
They have not read the act. You see, that's the thing.
So the executive committee has taken decision. It's not that.
Section 9 is.
My lord, page number 2 of that. But the word
Formal
therefore,
order.
the exhibit, this is 21st May. But therefore, second page, the executive committee being the competent authority in exercise of its inherent power under such and such is elected to. So would hereby decide to place him under suspension pending inquiry by appointing such and such magistrate first class as a.
When where's the order?
What?
Signed by.
But at the bottom,
this
madam.
order has to be signed by both.
Madam.
The order issued. He was.
But this is only a communication.
To him.
But this is only.
It does not mention about acting CM.
No, it is. The last paragraph, madam.
No, last paragraph we've seen, Mr. Chareso, see, is like this. Okay. Now he has a vested right to be considered for acting CM by virtue of him being deputy CM, correct? Yes. So then, if that is not considered, was the order served on you? Because as per the Act, he has a first claim.
Madam, therefore, the word may therefore Section 8. Madam, even Lordship kindly say Section 8. Consultation is not directory. It is not mandatory. It is directed. Lordship kindly see Section 8, page number 22, 23 of the writ petition. I understand the case of my learned colleague. The consultation is there, but Lordship kindly see Section 8.
Where's the Act page?
Page number 23 of the writ petition is there.
Yes.
My lord, if any, the office of CM falls vacant as a result of that resignation, retirement due to old age, removal or suspension, executive committee may, my lord, may, by order in writing, appoint the deputy CM to act as an acting chief.
Have you written down your order? Why? Is it considered there in your? Is it, where's the consideration?
The use of the
taken note of Section 8.
The use of the word may is because of the proviso, my lord.
The copy I have submitted, my lord, page number 2.
Once you use the word shall, my lord, then there cannot be any proviso.
My lordship, may I see?
Yes.
Page number 2, the last part, my lord. While keeping in the present.
No, where's Section 8 mentioned?
But it is not mentioned, but it is not. But the Act is not mentioned, but the power is already there.
That means it is an Act, by the Act.
But it is in consonance with the Act they have done. Madam, can you see the substance of the last part?
You've quoted there earlier on Section 7. Correct. Therefore, as a committee with a competent authority, exercise of inherent power in Section 7.
Yes.
So there appears suspension. But with regard to deputy CM, we have not quoted anything.
But the section is not.
Why you have not? You don't think it's warranted that you consult?
My lord, this is in persons of Section 8. My lord, they have done it. My lord, the substance of the decision, lordship, can you see? We have taken care of it.
The impugn order.
Yes.
Will have a direct effect on the other case suspension.
But it is a direct period.
In fact, though I have a filing appear, I have the instruction to appear for the acting. And I have taken over coronation, my lord, whatever customary, taken over.
Coronation for acting CM, Mr. Sen, please.
My lord, on 25th. 25th, my lord, charges were taken over.
Yes.
My lord, effectively in the control.
Yes, nothing that cannot be repaired, but the.
My lord, only thing I am pointing out, other case, my lord, you can receive, my lord, which your lordship is not taking a same prayer, you know.
Yes, anyway, take down. The instant writ petition directed against. This is given a number. This the order whereby deputy that's been appointed acting CM. This is.
Page 19, Lord.
Yes. The present petition is directed against an order dated 22 May 2026, whereby the petitioner, who is the present deputy CM, has not been found fit to occupy the post of acting CM in view of inasmuch as he is the younger brother of the suspended chief, for which the consideration for upon acting chief has arisen. The three main contentions have been raised by the petitioner. Firstly, with regard to the order itself, which has been signed only by a single executive member, which is against the mandate of section 25 of the Khasi Hills Autonomous District bracket appointment and succession of CM, Deputy CM, electors on Bashanong, Omnium Sanctionship Act 2007. Stop. Second contention raised is with regard to the express provisions contained in where the section? Brothers, whatever, nephew?
Section 9.
Contained in section 9. 9 bracket 1, which provides that it is a duty of the same in accordance with customary practice to nominate from amongst the adult brothers or nephews of the same to be the deputy same or same command. Stop. Third contention that has been raised is in the context of section 8 with regard to appointment of acting CM, which mandates that, which provides that when the office of CM falls vacant as a result of death, resignation, retirement due to old age, removal or suspension, the executive committee may by order and writing appoint the deputy CM to act acting CM, who shall exercise all the powers functions of CM, and a proviso thereto that if the situation so warrants, the executive committee may, in consultation with the Darbar, appoint a Khasi male adult belonging to CM Millim clan who fulfills the qualifications prescribed to be the acting CM of Millim Simshin. Mr. Firman Nongri Learned Counsel has submitted that in the instant case, the respondents have gone beyond the scope of the Act and has also submitted that the proviso referred to section 8.1 gives the executive committee the option to appoint any other Khasi male, but that should be in consultation with the executive Darbar. We therefore submits that the impugn order being in direct violation of the Act, the impugn order is bad in law and is liable to be set aside. Mr. H.L. Changreso, the paragraph Learned Senior Counsel appearing for respondents with Mr. So-and-so for respondent number
123.
123 has produced a set of instructions and submits that it's not correct that the decision or that the order was passed by the order was passed by the executive member and has referred to the minutes of the executive committee meeting held on
21st May
2026, yes, where he submits the fact concerning the petitioner to be the younger brother of the suspended chief was taken into consideration, and the same led to the order being passed. With regard to the other contention, the Legislative Council with regard to other contention as to appointment of any other male acting CM as provided in the proviso to section 8.1, Legislative Council has submitted that it is not mandatory, but is only an option that provided in the Act. With regard to the other contention, that is the mandate of Section 9, the Legislative Council has not advanced any arguments.
Regarding that point, my lord, Section 9 is not applicable. It is for general election and the filling up.
General election?
But it is the election of the to fill up the vacancy.
Yes, he said,
it's not for suspension.
That it's not applicable. Stop.
Yes.
This court has heard the counsel of the parties also examined the materials that have been placed. Stop. Perusal of the impugn order would show that the reason ascribed therein for disregarding the present writ petitioner's deputy's aim to be suitable for appointment as acting's aim is because of the fact that he happens to be the younger brother of the suspended chief. Further noted, the order, though emanating from the minutes of proceedings of 21st May 2026, has been signed by a single member on 22 May 2026. What strikes the court more is Section 9. And what strikes the court more in this regard is Section 9 of the Act, which has limited the consideration of appointment of deputy's aims from amongst the adult brothers or nephews of the incumbent's aim. The consideration, therefore, will naturally having been limited to the adult brothers or nephews, the reason ascribed in the impugn order cannot withstand judicial scrutiny. Lastly, as far as Section 8.1 is concerned, though materials have been produced by the Legislative Council, the only reason given therein is found in the impugn order itself. And no other reasons have been furnished or considered in the said meeting as to necessity of not resorting to proviso to Section 8.1. Stop. And in the conclusion of this court, the writ petitioner has made an overwhelming case for interference by this court at this stage itself, without even affidavit being on record. But however, to enable the respondents to present the case, they are allowed. When today is Monday, we file affidavit, bring it on record.
I'll bring on record.
Yes,
shortly.
Bring on record an affidavit, to place on record affidavit, enclosing all the necessary facts. We won't pass the interim order today. Yes.
Let
the affidavit be filed.
I'll file it quickly.
Even the compilation handed over.
I'm waiting for respondent number 4.
My lord, even in the compilation handed over to your lordships, even here, my lord, the appointment letter which was issued to them is like signed by the only one.
Under the parents, on behalf of respondent number
4, yes, 1.
Also brief allowed to put in a short affidavit to show the factum of his assuming office. Yes, 3 days time Is allowed. List the matter on Wednesday.
Let it be stayed till then, my lord.
My lord,
And
there would be a problem.
Lord, 2 days, my lord. What? No problem, my
We're
lord.
filing everything. I'll file it quick.
Absolutely no problem, my lord. Lord, can you have it on Wednesday? Can you stay till Wednesday, my
My
lord?
lord, we have strong.
Till Wednesday, my lord.
With great respect, my lord.
A new minor darbar, executive darbar has been constituted. This has
That will be a material. Nothing
My
material.
lord, great respect, my lord. I'll file it, very quickly.
No, file it.
Very quick.
We will
I'll
decide
note
finally Wednesday.
Yes.
It is further provided that the matter will be finally decided Wednesday.
Yes.
The other matter, you list it for another bench round.
Deeply obliged.
Orders for 15th is going. Where's Mr. Mozika and Mr. Sen? Hearing after lunch. It was only past lunch, yes. Then we sit at now it's only 2. Yes, 2:30. You have hearing matter, Mr. Sen?
No.
Yes.
1 minute ago.
Yes.
This one?
Yes.
Three matters are listed together: 208, 209, and 211. So let's kindly take up 209. Item number 16. Instructions. Where is it? 209.
Yes.
The instructions.
Vegetable, fruits, and is it a not? This is which for which place?
Here, what happens, my lord? Wherever the battalions are located, my lord.
What is which place is one?
Nagaland. All three.
Their case today was.
That's Mizoram, if I'm not wrong.
Yeah, Mizoram.
These are all Nagaland.
Yes.
209. Well, here what happened, my lord? Tenders were floated. 5 bidders participated, my lord, including the writ petitioner. 3 bidders were technically qualified. Their financial bids were open. Now the problem in these bids, my lord, lots of kindly sees. We have given the table. They've quoted excessively low price, my lord.
This is the first page.
Yes, my lord. The table will indicate, my lord. The lowest bidder was HMT Food Supply, who was a petitioner in this case, my lord. But his bid is 29% below the last year's price, my lord. Before the last year's price. The CCR means current contract rate. At what rate the supply is being taken now? And in fact, he is the same supplier who supplied last year also.
He quoted 1,29,000.
And which is 29% below the last year's rates, my lord.
Last year was 183.
Yes, ma'am.
Yes.
Even second one is 23% down, my lord, and third one is plus 9.57%. And then we carried out lots. We'll see in next page, my lord. From Dimapur market, we carried out some kind of survey, my lord. The market price of cut meat is 700 rupees per kg. He is quoting at 490. The broiler is 190. He is quoting at 134. Fish is quoting okay, reasonable, my lord. But mainly the problem is with these 2 items. That's why the department took a decision to cancel the entire tender, my lord, and refloat the tender. Tender has been refloated, my lord. So kindly see para 7, my lord.
Yes.
Refloated on 23rd of April. 11 bid.
You participated again, Mr. Sen.
I think
You participated.
Yes.
Then forget it. Why are you posting this?
No, please see that page 17 of my writ petition. Just to show your lordships the contractual stipulations with regard to this abnormally low bid.
How can you quote that much? Even lesser than last year, 29%.
Lordship, I understand.
And you were a supplier last year.
I was a supplier.
Then?
In fact, since the tenders have not been concluded, I'm still supplying. My order has been extended till the 30th of June.
Yes.
I was just reading out this particular provision, clause 8, subclause 4. This is with regard to abnormally low bids. It says rates quoted by firms, vendors, contractors found abnormally low. Bid of such vendor contractor will be declared as fictitious, unrealistic, and the EMD will be forfeited. Nothing as such has been done. No order has been communicated to me. A simple justification was sought. I replied they may not be happy, but there was no order as such. Now that's been repeated in all the cases. All I'm saying, Mulods, is a complete lack of reason. And in this manner, if this proceeds, in one of the cases, Lordship saying there's a third tender which has started. First 2 tenders have been cancelled, no reasons have been assigned. This may be one case where there's a case of abnormally low bids, but again, they've not followed the tender conditions. As far as the other 2 are concerned, no reasons have been assigned till today. So, Mulods, I believe this requires some sort of determination Merely because I've participated does not mean that I don't have a right to raise this particular issue.
Even then, once a new tender is floated, the new cause of action.
The cancellation itself is under challenge, my lord.
So what are we to do then?
No, my lords, this particular note here is only with regard to 209.
211, the next rate petition also is similar, my lord. There also. Now,
my lord, what your lordship will note, the theme here is...
He doesn't even have the locus, my lord, because the L1 bidder, he is someone else, my lord. 211. The rate petition is B traders, my lord.
Kumar.
Yes, Deepak Kumar is the L1, my lord. Mr. B traders, who's the rate petitioner here, he has quoted 32% plus. So even if he succeeds, my lord, the contract will go to Deepak Kumar too.
Now, my lords, we'll just look at this. This is a matter just for lordships to look at. The concern here is, assuming my bid is abnormally low, they don't refer to the contractual conditions, they don't declare that my bid is fictitious, my EMD is returned. The third person is also not allowed it.
Your EMD is returned?
Yes, EMD is returned. So there's no declaration that it is abnormally low. It is not a case that I am engaging in predatory pricing. That would be a serious allegation against me. But that's not the situation here.
But they kept your...
Look at the concern, my lord.
Otherwise, if abnormally low and if they see engaging predatory pricing, you'll be disqualified, barred from future tenders.
Correct. So that's not the case. They don't find...
You want to face that?
No, I'm saying, well, there is no positive finding against me.
In the sense that even EMD should be forfeited. Now they're giving it back. You're giving it back. So what is your concern?
My concern is this, my lord, that there is some different agenda here. Please look at number 2.3 in any of these lists. The third person who's the contender, he's also not allotted the tender. Assuming there is no concern with regard to his pricing. In this table,
we omit L1 and L2 and give it to L3. That also...
No. If L1 and N2 both are responsible for quoting abnormally low, why would they not allot it to L3? There is somebody else in contention. So there is something which is beyond what can't be seen through the records. There is L3 who's eligible, and this is not at the stage of technical bids, at the stage of the cost bid. 2 people are found to be disqualified because they've engaged in predatory pricing. But what about the third person? Why not allotted to the third person? And there are no reasons assigned.
The contract, they have the right to do, to cancel and refloat it. Suppose they have cancelled it and just allotted someone else arbitrarily, then maybe there's something else there.
Yes, there is.
But then here...
Because they're authorized to do that,
yes.
And I'm only submitting they have to have cogent reasons to support that. There must be a reasonable decision. There is no reason backing any of these decisions.
That we can only, it's irregularity in procedure, it's not illegality.
In fact, he's not happy with the lesser punishment.
Yes, I mean, he should be happy.
So we'll have to make out some sort of a case, will not
make out some case, but then your case is absurd. I mean, why you not freaking punishment on me? Why you give me back my EMD?
No, what I'm saying...
I mean, is that some, is that kind of case?
No, what I'm saying, will not...
Why didn't blacklist me? Then I would have felt that justice has been done.
No, Lordship.
Then we will pass the direction that now, like, since abnormally low, they should take the entire process forward. Blacklist him, bar him from future contract, who would hold EMD.
Lordship. Lordship, misunderstand me. My purpose of saying this was, if this sort of a procedure was invited, that would mean that they positively found that have engaged in predatory pricing. That's not the case here.
You want to come to a finding, yes. So you see,
they ought to have at least come to a finding, but they don't do so. They happily returned my EMD. So without any finding.
We direct that you deposit back EMD
and forfeit it. No, I'm not asking for that. I'm just saying that the procedure adopted by the department is questionable.
This argument, sorry, Mr. Zen.
I'll only place that before your lordship.
Not appealing at all.
My lord, at least have them file an affidavit in the meantime.
We'll file an affidavit. That's not a problem. On a 208, there are some issues. The justification given here may not be very convincing. Well, here what happened, my lord? There are 5 bidders originally. 3 were disqualified. Now the 48-hour window is there. They submitted the requisite documents and they were supposed to be technically qualified after that departmentally. But the GEM portal didn't accept that.
their queries.
Yes. So they fulfill the queries.
Yes.
But the justification is given, my lord. If I given third one.
This was at the stage of the first NIT. This case relates to 3 NITs for the same subject matter. In the first NIT, they found I had not submitted a trading license, but within that 48 hours window, I complied with that.
208.
Yes, no, 208. This is B traders.
Slightly different one. This one. So, my lord, originally 5 bidders, 3 were technically disqualified. Within 48 hours window, they submitted all the documents. So they were required to be, including the petitioner, were required to be declared as valid bidders, my lord. But there was some problem. Para 3, if I may just read, my lord. It is pertinent to mention that due to constant power supply, internet fluctuation at the time of technical evaluation, submission, wrong entries were published on the GEM portal, resultant 3 valid bidders, tender numbers of HMD, B traders and Devol Angami were declared as invalid, although valid. The system therefore proceeded for opening of cost bid. Observing the technical glitch, this branch approached GM authorities seeking clarification on reversing the technical evaluation result published, for which was intimated that GEM authorities that reversal of TEC result were not possible at that stage. Therefore, to protect the interest of valid bidders whose evaluation results were wrongly published, tender was cancelled. I propose to give all bidders equitable opportunity. The tender was refloated on GEM government portal on 7th March 26, wherein only 2 bidders were received. 2 bids were received on tender opening. Further, during the technical review, it was found B traders was technically valid, petitioner was valid, but HMD food supply was found technically invalid for not submitting EMD, which cannot be accepted during investigation stage. This was clear indication of lack of competition as per so and so, because there was only 1 bidder, my lord. So even that was cancelled. And
That can be cancelled.
And the third time it has been published now.
See, the thing is that I've not ever seen excuses like this for cancellation of a tender.
That's why I submitted my first case. But
So
that is
assuming that they found that mine was wrongly declared invalid, they could have given an extension of time, issued a corrigendum. That wasn't done. The entire game was cancelled and a fresh NIT was floated.
It was wrongly found invalid.
Yes,
Tender.
yes.
no matter that stage is over, my lord. Second tender was published. He participated in that. There were 2 bidders, but there was the sole technically qualified bidder, my lord.
But you cannot lose sight of the fact that this could also be deliberate. It could be deliberate. In case I find that I don't want to entertain these people, department may do something deliberately and assign this sort of a reason.
Can we look beyond that?
The fact that they admit that the cancellation itself was illegal.
How will the court discern or come to any kind of conclusion that whether this really happened?
No, I'm not saying not on the question of deliberate. I'm saying there's a possibility. Now, the very fact that they admit.
But then there's the reason given. How is the court to ascertain? How?
No, the very fact that they admit that the declaration of invalidity was wrong.
Yes.
That itself is a cause of concern. Now, whether it was bona fidely done or not, we do not know. We cannot simply accept their.
How will you ascertain that?
No, we cannot accept that for to be true just on face value. But the very fact that they do that itself is a cause of concern for me. That there was no reason for them to then simply cancel the tender and go into a second NIT or then a third NIT. They could have undone this whole situation by declaring that all of you are valid. We will proceed to the next step. That is the cost bid. What they did, as a knee-jerk reaction, they cancelled the entire tender.
See, they wanted to reverse the technical evaluation results. They said it's not possible. So
let them have the affidavit. Why is it not possible?
Once online, it goes, the process goes. Your bid cannot be accepted after that. Your technical evaluation, it cannot be revalued or reappreciated or reverse a technical bid
that is
to have to declare you valid, because wrongly you found invalid because some power issue, right? So now, if it's an online system.
Again, we don't know whether it's possible or not.
Understanding, it won't be possible to reevaluate once.
Let me obtain instructions on this. Whether
OMR sheet.
No. Let me obtain instructions whether.
I was here in this court the other day. This fellow sports person, by mistake, he shaded in the A, not sports person.
Right. Correct.
And against a sports quota, and he was a sports person.
No, I'll obtain instruction in this matter. How does this whole GEM portal work? In case there is some sort of an error, and what was responsible for the error, can it be reversed? So at least as far as that is concerned, let us examine that, Varun.
Yes, 209. Dr. Musica, JCI has these instructions, which indicates that the cancellation of tender was occasioned by rates that were abnormally, the rate that occasioned due to the abnormally low rates quoted by the writ petitioner
209, yes.
and another bidder. So he submits that this situation that fresh tenders were floated. So he prays it loud to place the instructions by way of affidavit. Yes. You want to write the objection regarding why my EMD was returned? Or not necessary?
If I may, your lordships may record it, at least for the satisfaction of the clients that have raised this issue.
Yes, Mr. SN was submitted that if that was situation as per the terms of the tender, as per the terms of the tender conditions, the EMD of the petitioner should have been forfeited, or he may be, or should have been barred from future participation.
But it doesn't say that, my lord. It only says declared as fictitious, unrealistic, and forfeiture of the EMD. Yeah. Only to that extent.
Forfeited and his bid declared fictitious, so which was not done by the respondent staff. Be that as it may, then affidavit be placed on be filed, placing the instructions on record. Yes, list after
2 weeks, 3 weeks.
2 weeks.
We may just also point out, this is not disputed, all these petitioners they're currently supplying because they were originally tender holders.
We won't.
They're continuing till 30th of June in any case.
We won't go there. Yes. And in 211.
Only difference, my lord, 211, the petitioner is not the L1 bidder.
In the present case, it has been submitted that the locus of petitioner is in doubt in as much as he is not the L1 bidder. However, the reasons given for cancellation tender is also the rates that are quoted being abnormally low. Leonard GCI to file an affidavit. Yes.
In this last matter, in the first round I was L3, but in the second one, the tech bid 211, my lords. That first round has been cancelled. In the second round, tech bid has not been finalized as yet. That's the only clarification.
He's not L1.
He was not L1 in the first round.
211.
211.
The 211. The reason Dr. M. Hosika submits that has produced instructions and submits that the reason for the cancellation of the first tender was due to technical issues, technical power issues, wherein the writ petitioner and another tenderer, though valid, were declared invalid. It is further submitted that though the respondents had approached the GEM authorities seeking clarification reversing the technical evaluation, they were intimated that the same was not possible. So he submits that in this situation that the tender was cancelled and refloated. With regard to the next paragraph, the second tender dated 7 March 2026, he submits only 2 bids were received, and further after technical evaluation, only 1 bid was found to be valid. It was in this consideration that the second tender was also cancelled and the third tender floated on
22/3/26.
Yes. And so he prays funds out to bring the same by way of affidavit. This after 2 weeks.
Obliged.
Hearing.
Let's have some delay.
My lordship, I'm praying for adjournment for today as my leading counsel is not in keeping well.
Is that matter in pendant light maintenance or no? It's different.
Succession certificate, Your Lordship.
What's your name?
G. Pingroom.
And Miss G or J?
G.
You were placed for accommodation due to the illness of the Housing Council for the respondent.
Can we just have 1 week, Your Lordship?
1 week.
1 week.
Just a matter of 1 week.
Hello, blood.
Where were you this matter?
Yes. My Lord, wide order dated 10/9/2025. My Lord, they sought time to obtain instruction with regard to what recourse the appointing authority takes if they are disagreement with the findings of the departmental screening committee. That is in my favor. So now 8 months they have sought time, but no instruction has come forward.
Lordship, if we come to page 90, Your Lordship.
Not of the petition. Just come to this order date 10/9/25.
Yes, Your Lordship. No, these are the compelling circumstances where the consideration of the appointment was not considered.
No, but then you see, if the screening committee had recommended and appointing authorities in this agreement, what steps do you? What
the department screening committee is just the recommendation committee.
Yes, but then can the appointing authority overrule the findings of the screening committee?
Yes, Your Lordship. Because see, that's just what I am telling Your Lordship. If you come to page 90, Your Lordship.
90.
90
Of the writ petition.
of my affidavit, Your Lordship. Are you there, Lordship?
Yes.
Lordship, this is the letter dated 03/1/2025. This letter has erupted only after this honorable, this Your Lordship has passed the order to revisit the matter. So after the headquarters has revisited the matter, then this letter came up, Your Lordship, which was addressed to the petitioner. To so and so, this is the petitioner, Lordship. The subject is compassionate appointment of Lakshmi Joshi, daughter of so and so. In referring to the Honorable High Court of Meghalaya order dated 16/9/2024, in the writ petition number 230 of 2022, it is stated that the respondent were directed to visit the matter, taking the screening committee report into account and pass appropriate orders thereon. I am now directed to inform you that the competent authority in headquarters office has revisited the matter, keeping in view the screening committee report, and has not accorded approval for your appointment on compassionate appointment on the following grounds. These are the grounds, Lordship. The welfare officer, in his fresh evaluation report dated 25/10/2017, has stated that the family pension is the only source of income and none of the dependent family members is having any government job employment. They reside at IA and AD staff quarter and do not have any own house, land, immovable property. Shri Deepak Kumar Joshi, the eldest son of the deceased employee, after marriage left the family and they do not know his whereabouts and there is no connection with the family. However, he left his child to his mother and sister, the applicant. Shri Kishan Joshi, the younger son of the deceased employee, is employed in the central government department and he does not support the family financially and has no contact with the family. Number 2, Your Lordship here. However, in the earlier verification report dated 20th/7/2015, it was stated that Shri Deepak Kumar Joshi is unemployed but married and having one child. He and his wife are not staying with the applicant's family and left the child to his mother and sister, applicant. However, as per welfare officer's report dated 25/10/2017, Shri Deepak Kumar Joshi, after marriage, left the family and do not know his whereabouts and there is no connection with the family. The statement in verification report as reproduced in para 1 and this para, which read in conjunction, appears to be contradictory.
It was 2 different years, 15 maybe unemployed, then after he got married and then...
No, the fact is that now they got married, they leave the children with their child, with the applicant and the mother. Now they will also become dependent. Now they cannot just state claim that whatever they're doing in the family and my office will be answerable for that, Your Lordship. Here, Lordship, can you come to this number 3, Your Lordship? The DSC in its minutes dated 20th/10/2015 stated that Shri Kishan Joshi has declared his mother and brother as dependent. However, it was noticed from the letter dated 7/11/2017 of the Commissioner Special Bureau, Shillong, that as per their records, Shri Kishan Joshi has no dependent. Shri Kishan Joshi has given his permanent address of Shillong, indicating thereby that he had not severe the relationship with his family. This apparent inconsistency has not been addressed, and in view of this, in such extreme caution has to be observed in ascertaining economic distress of the family members. Further, as per the welfare report, officer's report dated 25/10/2017, even the information regarding house, land and immovable property is based on verbal statement of the candidate and her mother without any independent verification. Such report cannot normally be relied upon. Number 4, the DSC has stated that after taking into consideration all the information provided by the administration, the welfare officer's report and the Honorable High Court of Meghalaya order for reconsidering the case, recommended the case of Lakshmi Joshi to the post of clerk against the existing vacancy during the period of 17 and 18. However, the DSC has not justified its recommendation to offer appointment to Ms. Lakshmi Joshi on compassionate ground by relaxing the norms where there is an earning member in the family. In view of the above, the case of Lakshmi Joshi has not been given approval by the competent authority for appointment on compassionate ground in terms of para 11, that there is an earning member as per the Department of Personnel and Training Office Memorandum dated 16/1/2013, Your Lordship. So whatever the headquarters has in all the impugn orders, Lordship, it has been issued to the petitioner here. It's all in terms of this para 11 of the scheme of compassionate appointment.
Yes, Mr. Pandit.
My lord, the departmental screening committee has already considered all this aspect, and in the departmental screening committee report,
But then one thing is that
there is no other independent body to examine any further. It is the screening committee is the body of the respondent.
More than 12 years, Your Lordship.
Respondent only they have constituted to
how is the
examine.
petitioner surviving?
That is the question,
My
Your
lord,
Lordship.
still she is unemployed. She is married, but husband is also unemployed. But she is just
Husband is unemployed.
yes. Husband also he is taking tuition, private tuition.
Now where is that fact? You put it in the petition.
My lord, that marriage or not married, that is not the as per the scheme. My lord, even the married daughters are entitled for the appointment. But
How old
only
is she now?
hello?
How old is the petitioner now?
Now 40 years.
She passed her class 12 also, Your Lordship. She could work anywhere.
No, that is not the ground, because the
depend on-
delay since 2012 I am pursuing this matter, my lord. 2 times this honorable court has considered. Once the honorable high court was pleased to direct them to consider her matter sympathetically. Then again my lord was pleased to pass necessary order directing the respondent to take into account the departmental screening committee report.
But things changes, Your Lordship.
And then my lord, there is no other body, independent body. They are the authority who will constitute and examine my
I would like
status.
to rely on this judgment, Lordship.
Which paragraph?
This para 28, Your Lordship.
Compassionate ground because the only time is a consideration.
Yes, Your Lordship.
The longer
And even there's an observation in this judgment,
the
Lordship.
longer it takes, your chances become slimmer.
Yes, Your Lordship.
And suppose then immediately after the death of the employee, then to make
To tide over the sudden crisis.
the financial distress. Yes. Otherwise, the longer it takes, that means yes.
Yes, this para 28, Your Lordship. These are the points of consideration. The following points would arise for consideration: whether the division bench of the High Court of Calcutta erred in allowing the appeals filed by the respondent and petitioner and directing their claims for compassionate appointment be considered by the applicant. What order? These appeal primarily concern, Lordship, we come to this policy of compassionate appointment, Lordship, that last paragraph. The majesty of that is that in the great leveler, for it makes no distinction between the young and the old, or the rich and the poor. That being as a consequence of birth, in some point of time, it is inevitable. For long being, thus While death is certain, its timing is uncertain. Further, the deceased employee does not always leave behind valuable assets. He may at times leave behind poverty to be faced by the immediate members of his family. Therefore, what should be done to ensure the death of an individual does not mean economic death for his family? The state's obligation in this regard, confined to its employee who die in harness, has given rise to scheme and rules providing for compassionate appointment of an eligible member of the family as an instance of providing immediate succor to such a family. Support for such a provision has been derived from the provision of Part 4 of the Constitution of India, that is Article 39 of the Directive Principle of State Policy. Number 31, Lordship. It may be apposite to refer to the following decision of this court in rationale behind the policy of scheme of compassionate appointment and consideration that ought to guide determination of claims for compassionate appointment. Lordship, number 1, in the case of Sushma Gusain and Union of India in 19 so-and-so, this court observed that all claims for appointment on compassionate ground, there should not be any delay in appointment. That the purpose of providing appointment on compassionate ground is to mitigate the hardship caused due to the death of the bread earner in the family. Such appointment should therefore be provided immediately to redeem the family in distress. Next, Your Lordship, in Umesh Kumar Nagpal versus State of Haryana, 4 SCC 138, the court observed that the object of granting compassionate appointment is to enable the family of the deceased government employee to tide over the sudden crisis by providing gainful employment to one of the dependent of the deceased who is eligible for such appointment. The mere death of an employee in harness does not entitle his family to such source of livelihood. The government or the public authority concerned has to examine the financial condition of the family of the deceased, and it is only if it is satisfied that but for the provision of employment, the family will not be able to meet the crisis. That the job. Para 32. Yes, Lordship. Para 32. On consideration of the above decision of this court, the following principle emerges: that the provision of compassionate appointment makes a departure from the general provision providing for appointment to the post by following the particular procedure of recruitment. Since such a provision enables appointment being made without following the set procedure, it is in the nature of an exception to the general provisions as must be restored only in order to achieve the stated objective, that is to enable the family of the deceased to get over the sudden financial crisis.
You got a copy of this? No.
Okay. Lordship, if you come to this 35, Lordship, paragraph 35. Considering the second question referred to above, in the first instance regarding whether application for compassionate appointment could be considered after delay of several years, we are of the view that in case whether for reason of prolonged delay, either on the part of the applicant in claiming the compassionate appointment or on the authority in deciding such claim, the sense of immediacy is diluted and lost. So here, after 12 years, Your Lordship, now its circumstances has changed, their life has changed, and we all grow, Lordship. In years to come, we all grow. So they also must have grown.
So you say it's a dead cause of action?
Yes, Lordship.
By the lapse of many years.
Yes, Lordship. They are being able to survive after 12 years. For 12 years, Lordship. So the applicant's mother also, who after the death of the incumbent, I think around more than 10 lakhs, they got the terminal benefits, and now she is getting around 21,000 per month as
the mother's alive.
The wife, sir. Yes, mother of the applicant. So she's getting 21,000 per month as a family pension. Prior to that, in 2024,
not 21,000.
Prior to that, in 2024, because he was considered to be still in service because he died in harness. That time she was getting more, Your Lordship. So now in 20 or 21,000, whatever she's getting, Your Lordship, she could take care of herself. Now the applicant is married.
In this case, my lord,
She's getting family pension.
2000.
Sorry, Lordship.
Who's getting family pension now?
Wife.
The wife.
Is still alive.
She's still alive.
2014 he died, my lord. And 2014, after 4 months, I applied. 2014 itself. And my lord, there are since 2014 I am pursuing this matter. There is no delay on my part. And if your lordship will come to paragraph number 59, my lord, that is 63, my lord. My lord was pleased to pass this order. Without adverting to the submission rendered by the respective counsel, it is seen that in the screening committee report dated such and such, the case of petitioner has been considered favorably, but however by order dated such and such, the same had been summarily rejected. Last time also they rejected on the ground that there is an earning member in the family.
In all three times, Lordship. I'm not saying this once.
Yes.
All the 3 times which was rejected, the new order under challenge was rejected in paragraph 11 of the commission.
Whereas the departmental screening committee has come to a finding that that person, that son who was employed, he has not been looking after the family.
That is why.
And this honorable court.
Back all his arguments.
Yes, my lord.
Come with the last order of this court.
Yes, my lord.
That order, what is that?
Without further going into
2025.
though much time is elapsed in view of the cryptic.
The thing is that you said that what is the recourse taken to if the appointing authority is not agreement with the financial committee. Now the only thing you say that is contradictory, because in the time when the examination or the inquiry was 2015, it was reported that, I mean, to the inquiry, whoever was doing inquiry, that this fellow was still staying there unemployed, had a baby, and so he's eligible. Then second 17 report says he married, left behind, and left the baby behind.
Yes.
Something like that, correct?
Yes, my lord.
So such cases,
that will not make any difference, my lord.
What does the department do?
What will the department do, your
on
lordship?
17, they found out that yes, that she's eligible for compassionate appointment. That's the only thing. So 17 to now, whether the delay can be
attributed to me or by them.
To him or to you.
That's what, lordship. Now, even the family member who is the earning member and who is working the government servant as a government servant, what prevented him to not make them as dependent in his service?
That is
his own personal choice.
Yes, that is departmental committee has already taken care of that. So that was the body which was constituted by
had he made them as dependent, they would have availed all the benefits of a central government.
That question
schemes.
You could have raised while departmental committee was constituted, but you have also favored me by examining all those aspects, and now again you are taking U-turn.
So my humble submission is, lordship, this para 11 of the scheme is
and this
very
honorable
important.
court has posed this question also by order dated 10.
Scheme 11, lordship, this of my.
Had there been delay on my part, then of course I had no fear.
Where's the earning member?
Yes, lordship, page 45. Where there is an earning member. In deserving cases, even where there is already an earning member in the family, a dependent family member may be considered for compassionate appointment with prior approval of the Secretary of the Department, Ministry concerned, who before approving such appointment will satisfy himself that grant of compassionate appointment is justified, having regards to the number of dependent assets and liabilities left by the government servant, income of the earning member, as also his liabilities, including the fact that the earning member is residing with the family of the government servant. And whether this is page 46, your lordship, 45 and 46.
You know which department is this?
AG, Accountant General.
Oh, okay. Working as?
He was MTS, lordship.
Multitasking.
Grade 4 employee.
Died.
Yes. All this aspect has been considered, assets and liabilities.
CACB will apply to your case.
Extreme cautious. Caution has to be taken, observed. So these are the extreme cautious that we have taken, lordship.
What is the favor screening committee has found out earlier on?
Lordship, my humble submission as a screening committee report is just a recommending authority, lordship. It's just the administrative duty.
We'll end it.
Yes. Yes, Lordship.
We'll pass orders. Yes.
Highly obliged, Your Lordship.
Can we comment in next session?
Well, the difficulty is that the result of NEET is valid only for 1 year, my lord. And there
What
are
point does need? Why do you need to need?
But that relief can be molded. There are decisions of the Supreme Court. Your Lordships, in fact, passed a decision on similar lines, where admission to the next academic session was fixed on the basis of the previous NEET result.
I'll try to distinguish that, my lord, because there was the default on the part of the administration, my lord. There were some mistakes. Now here's a case, and out, it is the petitioner's mistake, my lord. He arrived late. And
for a few minutes, I think it's a
there are several
little
reasons,
harsh.
my lord. Several reasons from the. I'll place those decisions. Where the facts are, Lord, I think should I place the facts?
Well, allow me to start with. I have a different perspective on the
Have it,
facts.
Sometime later this week then.
Let's then have it tomorrow. It'll be very short. I won't take too long. Half an hour at the max.
What are the DB is there? That's a problem. That day after then.
Day after, sir.
It's a matter of further hearing on Wednesday.
Wednesday.
Gets to, because by I'm sure private secretary is also there's a thing.
I understand.
Yes.
Obliged.